Can I just say something about Andrea?
Hey guys, welcome back. It has been a minute since we've had anything new and interesting to watch in the Tyler Robinson case. If you are following my Substack, checking out the legal documents, I am continuing to post those as they come up. So we are up to, let's see, 228 documents now on the docket as of I think Tuesday was the last time I checked and updated. So, a lot going on behind the scenes that doesn't necessarily get a lot of attention out in the press and in the media. But I will concede that, at least for the most part, what has been happening has very little to do with the substance of the case, the evidence, the material issues relating to guilt or innocence and stuff like that. But what it's really been about is transparency, which, of course, as many of you know, is quite an interest of mine. I continue to be unsure if this is like, a new phenomenon for there to be so much secrecy associated with criminal cases, or if it's just I don't know, just seeing it more now, paying more attention to it, maybe something different in the way that we get our media about court cases and things like that. But just kind of continues to be an ongoing thing, this battle between what are we allowed to see, because it might make us pre-form opinions about whether Tyler Robinson is guilty or innocent, and that would potentially affect his right to a fair trial, versus we kind of need to know what's going on so that we can evaluate if this is fair, if this is corrupt, if this is legit, if there's like shenanigans that we the people should be concerned about going on in our government. And so there's no way to do that without knowing what the court is doing, what decisions it's making, and what it's basing those decisions on. So one of the things that happened fairly recently, there's been some motions filed relating to the gag order. The state has kind of questioned the scope of the gag order, the basis for it, the justification, echoed a lot of the concerns that I had brought up when I did my live stream on the gag order way back when. And so the defense has responded, essentially saying not only is the gag order fine, but they actually intend to ask to expand it. They want more people to have to shut up about what is going on with the case, what they know, what type of evidence they might be providing, and so forth. So the media has gotten involved. We've got a couple different sets of media, like consortia, that have gotten together, hired themselves lawyers, and they've started to contest some of these issues relating to what we're going to get to see and what we're not going to get to see. Some of this is technical, like there's arguments about whether the media should be allowed party intervener status, or just have an opportunity to be heard on issues relating to public access. I got to tell you, it's just, I wrote about this a little bit on Substack too. It's a little bit bizarre to me how the defense is really prioritizing this fight, kind of what they're choosing to spend their time on. They're far more involved in the litigation about these access issues than the state is. The state is, other than the gag order, just been kind of, we're staying out of it, and the court can use its own judgment and stuff like that. But the defense, for example, took the time to research and file a fairly lengthy brief about why they don't think the media should be allowed party intervener status. And if you want to go through and read that, do it. I find it odd because the defense is raising like technical legal arguments. They don't qualify because X statute and Y procedure and things like that. But nothing in it communicates to me like, why do you even care? Like, what's your stake in this? What practical difference does it make to you if they just get to appear in court and oppose, court closures, document sealings, and things like that, versus they get recognized formally as party interveners? It's just a little bit bizarre. The media's argument has been they need the special status because if the judge rules against them, they don't have a right to appeal unless they have some kind of recognized standing in the case. So it seems to be a pretty decent argument from my perspective. So this is all what's kind of swirling in the background as we're leading up to today's hearing. And what today's hearing is going to be about is this very specific issue of the transcript from the October 24th hearing. So let me back up in case you haven't been following this super closely. What happened is that back in October, Tyler Robinson had filed a motion to be allowed to appear in court in civilian clothing and without shackles on. And he argued that, this is fundamental to him being able to get a fair trial because there's going to be a lot of publicity about this images. It's being live streamed and so forth. And so, having him on camera in the prison orange, or whatever, it creates an association in people's minds that like, oh, he's already guilty or he's really dangerous or something like that. So the state responded to this motion and they asked for their response to be sealed, and that request was granted. So to this day, the state's exact position on all of that, we don't know what it was. It's a sealed document in the court file. It's never been made public. And so all we really know is the hints that we got from the defense's reply, where they talk about some of the things that the state said, and then also the ruling itself that we got from the court live in the last hearing that we had, as well as a written order that the court filed. But in response to this issue about the response needing to be sealed, and the state's argument was because we need to discuss courtroom security measures. If we're going to be talking about whether he needs to be shackled or not, we need to talk about, what kinds of safety measures are already in place, how we make those decisions, how we do those assessments, how unshackling him might affect that or undermine our ability to do that. And, the problem is you can't really do that well in a public forum because now, your entire methods are public and people can start to look for holes in them if they want to. It's just kind of an OPSEC issue that you don't, tell your enemy everything that you're doing to try to keep yourself safe. So based on that, the court had a hearing on October the 24th that was closed to the public. And again, because it's closed, we don't know exactly what happened. We don't know if there was evidence presented. We don't know if they just argued their positions. We don't know what was said. We don't know any of that. So subsequently, request for a transcript was filed. The court agreed. The transcript was made private because the hearing had been sealed. And that's where then the media got involved. Media got involved and basically said, look, you don't have a justification to just conceal this entire transcript from the public eye. There seems to be plenty of indications that lots of stuff that happened at that hearing is not the kind of thing that justifies keeping it away from everything. You didn't spend the entire hearing just talking about how the court and how the sheriff's office and so forth do their security. So to the extent that there's anything like that that needs to remain unavailable to public inspection, you can achieve that by redacting it. You need to be selective with your decision that certain parts of the process should be beyond public view. So that is ultimately what this hearing is going to be about. It's going to be about the October 24th transcript. What, if any, of it needs to be redacted? It does appear at this point that at least some of it is going to be made public, perhaps even most of it. since the media got involved, the state and the defense got together. They filed a stipulation where basically they presented a joint position that there were certain things, like certain lines in the transcript, that they felt needed to remain confidential. So these things should be redacted. And they asserted some different reasons for that. Some of them did involve courtroom security, but then others are a little bit more ambiguous. They just reference things like privacy interests. They reference things like right to a fair trial. So the press has kind of taken issue with how they've done that as well, how they've presented their objections, because they're saying, look, we don't even know what this is. We don't have any basis to be able to evaluate if this is an appropriate reason to be redacting information or not. Like, you need to be at least a little bit more descriptive about what it is that you're saying occurred, so that we can, meaningfully evaluate if we think that that's necessary or not. This is also going to be the first live appearance of Tyler Robinson in the courtroom. So I kind of expect, honestly, that's why it might get more attention than otherwise. The merits of what we're going to be hearing might call for. Certainly I am very interested in courtroom transparency. A lot of the media is likely interested in courtroom transparency, but I don't imagine that, like, a lot of folks interested in who murdered Charlie Kirk are necessarily like that all into courtroom transparency, just as a principle and a practice, and why it's grounded in the First Amendment and how it relates to our right to petition government and so on and so forth. But there's kind of a spectacle side to it. There's an information gathering kind of side to it. People want to be eyes on Tyler Robinson to see, he's been in jail for 3 months now. How does he look? How does he deal with his lawyers? How does he behave? What sort of, clues are they going to want to try to ascertain about him and the case and where the defense is going and so forth, just by being able to watch him. So the judge so far has been, from my perspective, pretty good on transparency. I mean, we did have the little thing with the state's response, just being flat out sealed. Don't really love that, but certainly, at least once the media got involved, he has, from my perspective, said the right things and kind of done the right things when it comes to protecting the public's right to watch. He continues to allow the cameras in the courtroom for, pretty much, I think, every hearing other than the October 24th one that, you couldn't attend in person either. So his record so far, seems to be pretty good on recognizing the fact that, look, we know that there's a lot of public interest in this case, and so if we keep things behind closed doors, that's just going to generate more suspicion. That's going to make people more distrustful of what's happening, which is is perfectly legitimate. I mean, this is why we have public records laws and open court and stuff like that in the first place. Is the government is supposed to belong to us. It's of, by, and for the people. It's not like some monarch, who sits out there and does what they want and kind of decides for themselves if we get to participate in it or not. And so there is a court decorum order as well that is relating to the use of the video cameras, and I'm bringing this up because we're this is going to be a little bit of a test. And those of you that followed the Koberger case with me, you will remember what an issue it was with the cameras, because the primary interest in the media is not going to be on the intricacies of this legal argument and the cases that they've cited and so forth, and who are these attorneys that are appearing for the different people. That's not what they're interested in. They're interested in staring at Tyler Robinson. And so In the Koberger case, it was just like, we're like zoomed in on him constantly. We're like trying to, get every little tick, every little, reaction and stuff like that. So that kind of got to the point of being a problem. The court ultimately told the media, don't do that. Media just couldn't resist. And so what ended up happening was that the pool camera, the media camera, got yanked out of the courtroom, and the judge says, we'll continue to televise it, but you're going to use the court's own, like the Zoom court system. And so that way, we don't run into this situation where, again, it's just kind of potentially prejudicial to him to be creating this not just like detailed inspection of him in court, but it's far above and beyond anything that you would be able to do if you were actually like there in court as an observer. When you're in court as an observer, you're usually sitting in the back, you're behind them. You don't have a, up close, zoomed in view of the defendant's face to be able to like try to see every little tick and things like that. So it's kind of creating a, an opportunity for this, suspicious and detailed type of, very potentially prejudicial opinion forming about somebody based on things like, you might be nervous in court, your first time in court. You got all these cameras here. You got all this, your life is at stake. You might be acting in a way that isn't how you would act in your normal life, in your house, walking down the street or something like that. But people love to read like personality characteristics and try to just kind of psychologize and divine things about people and based on the limited information that we have. And since at this point Tyler's not speaking, and he's not gonna speak because he's got some of the best capital defense lawyers in the country sitting there at the table with him, who are going to make sure he does not do anything that is against his best interests. Well, then we have really limited information to be able to work with and to be able to, try to form opinions and judgments about, who is this guy? Is he crazy? Is he a lost kid who was led astray by some people on the internet? I mean, lot of different, possibilities. And, rather than just kind of being patient and wait to see how the case plays out and what sort of evidence is presented and so forth, people like to just go with the information that they have available. So anyway, we have not seen cameras behave in the courtroom yet when Tyler is there in the courtroom with them. So we don't actually know, what are they going to do? Is it going to be like Koberger, where we're just going to be like fixed on him the entire time? Are we going to be like, a little more responsible, panning the courtroom, watching the people who are speaking, things like that? And depending on what they do, that might lead to more arguments down the road about how they need to behave. So far, the restrictions that have been placed on the cameras in the decorum order, the court has indicated, because he's not allowing Tyler to be unshackled. He's going to be in civilian clothing, but he's still going to be shackled in court. And so the judge has said, you're not allowed to film him coming in and out of court because that will make it obvious. You don't walk normally when your hands are bound and your feet might be bound and so forth. And also they're not allowed to film his shackles. So, I guess I'm assuming that means they're going to have to stick to like a, chest up type of view of him. Might limit, straight on, like long views, behind views, if he's got shackles on his ankles or something like that. So those are the only restrictions in the decorum order. But then he's also put a couple of restrictions on the authorization, the order that's allowing the media to televise and live stream this proceeding in the first place. And that includes not allowed to televise or show. You're not allowed to film any witnesses. You're also not allowed to film his family. So this was like specifically called out and noted on the most recent most recent order for this. And it caught my attention because, of course, we haven't seen Tyler's family yet. And there's an awful lot of speculation about Tyler's family and how they fit into this particular case. Of course, we know from the probable cause affidavit and the charging document, Tyler's parents appear to have been involved in handing him over to the authorities in the first place. They have made statements attributing, comments that he made to them, some admissions, perhaps statements against self-interest, implicating himself in the shooting. They've described kind of the events that led to them being suspicious that their son might be the person that committed the shooting. But since then there's been we haven't seen them. They haven't given interviews or anything like that, which is from my perspective, not only like 100% in their right, but also really expected that the family is going to, be distant from this, because this is still their son. And regardless of what they think that he did. And so I just, I always come back to the families of the accused perpetrator. They suffer in ways that get really little to no recognition, little to no sympathy. I have every reason to think that Tyler Robinson's parents love their son. They held him when he was a tiny little baby. They dreamed about the life they wanted him to have. They envisioned him as, being a leader of men, achieving great things, making a big positive mark on the world. This is, I think, a pretty normal kind of parent experience. And so when you find out or come to believe, right or wrong, that your son might have done something like this, it shatters all of those dreams in an instant. So the family is going through an extremely traumatic process. The family is grieving, the loss of the dreams that they had for their son. Whatever happens at this point, his life is irretrievably changed. It's going in a different direction, regardless of whether he's convicted or not. He's in jail. He's having to, deal with that indignity and that, jail can be kind of dangerous. Jail can be quite unpleasant. It can be not a real fun place to be. So I'm not at all surprised that his family is dealing with this type of thing in private. It's 100%, what I would expect them to be doing. But I know that just kind of given the environment around this case, the climate around this case, there's a lot of interest in his family because of the fact that they, by appearances, are going to be witnesses for the state. And so there seems to be like some expectation that they're going to publicly comment or otherwise kind of be involved in I don't know, publicly litigating the case in the court of public opinion. But we're not going to see them, right? The judge has made it very clear not to film the family. Which, frankly, from my perspective is very appropriate. But it does, of course, raise questions now about, is his family going to be there? Like, is that why you put this in the order? It hasn't been in any other order. So do we have an expectation now? Like, did he learn, through email or somebody let him know, hey, the family's going to maybe show up for this one. So he puts it in this order. It's possible. Things like that happen. We have seen that they have done some of this administrative kind of business before, behind the scenes through like the email channels and so forth. But then, of course, the big question is going to be, well, if his family is there, like, what does that mean? Are they, if they support him, does that mean they think he's innocent? Are they still, standing by what they told the prosecution and stuff like that? I'm just going to kind of go back to a point that I guess I've tried to make when I've talked about this case. I was on last night with Gary Melton over on Paramount Tactical. I'm very bad about announcing these things. I meant to make a community post to let everybody know, and then I forgot. But I did go ahead and link it down on my page on the appearances on other channels. Anyway, we had a very good long conversation about kind of just the evidence that's known so far, what's not known, where these investigations go, what the court process is going to look like, and stuff like that. But one of the points that I think is so important to remember about a case like this, because we are still very, very early in this process. In court time, I realize 3 months seems like a really long time in news cycle terms, but in court terms, this is like yesterday, and things have barely started to happen. But there is nobody who has a greater incentive to bring up or point out issues in the case than Tyler Robinson does, right? He is the one whose life is on the line. And so if there is any reason at all to think that like his parents dispute the state's version of events, or that there are like shenanigans with evidence, or anything like that, that there's like misconduct happening with law enforcement planting evidence, or destroying evidence or things like that, which is a due process violation, a Brady violation, all these types of issues, they are the ones who are going to be the first people to bring that up in court, to raise that, not just because how many eyes are on this case. And so the perspective so far in the media and in the public has been solely the state's version of events, because that's all that we've seen so far through the process. We're at the probable cause stage. That's all that there really is. And so, first off, that if you file something that's got allegations like that in it, it is going to spread like wildfire. Okay. The media are going to love that. That is new information for them. That's a story that they have. People are going to want to click on that and read it. And so you're always going to be thinking about stuff like that in a very high profile public case like this. How and can and should we be kind of correcting, balancing out the public narrative about this case? They've heard so much from the state. We need to make sure that when there are, valid, strong, legitimate concerns, that is also being aired in the appropriate way. But also, again, his life is at stake. And these are the types of issues that have the potential to take the death penalty off the table, to have evidence challenged, to have like mandatory instructions given to the jury about what they should think about certain actions or inaction, by law enforcement. So they have every incentive to litigate this from a legal standpoint, not just from a PR one. So I'm very, skeptical about any reason to be concerned about stuff like that, at least at this point, because the defense will raise it if there is a problem. They have every reason to do that, and no reason not to. So we got it on. Looks like they're getting ready for stuff, but of course nothing is really happening yet. Oh, there he is. So they brought him in, and yes, we're going to have the old Koberger Zoom. We're going to have him inspected. The lip readers are going to be out. I can already envision that this is going to start presenting some grounds for the defense to be arguing. We need at least some ground rules on these cameras. If not, potentially trying to bring them out altogether, because the defense has generally been more hostile to the public inspection than the state has.
Nothing to follow up further. That too. That's my. I see. I'll identify one of the sense. Yeah.
So these do appear to be his, I'm assuming I recognize Catherine Nestor from the back here. She's one of his Utah attorneys. There is a woman named Stacy Visser who's appeared, also a Utah attorney. I believe that might be her over on the other side, but of course I don't know for sure. Don't know nearly as much about her. She doesn't appear to have kind of the sort of high profile background that Ms. Nestor has. Ms. Nestor is the defense attorney for Corey Richens. Just for one, it's another high profile case that's going on in Utah right now. He's also got a pair of attorneys from out of state, from California. They're both highly experienced capital defense attorneys, litigate death penalty cases all over the country. So it doesn't look like they are personally present, unless, that guy there is one of them sitting at the table. So he probably is. But, since we're still in the early stages of this case, we're still kind of getting to know who the players are and so forth. I'm going to try refreshing this to see if I'm hearing it's choppy. See if I can get that to show up a little bit better. Ashley's saying Law and Crime has a better feed. Let's see if I can find it real quick. Is it Trials? Law and Crime Trials? Yes. Let's see if that might be better. Let me share this one instead. And give me a second here. Close out this other one. Let me know if that is working a little bit better. I normally like to give it, give the views to the local folks, but that's fine. We'll just go with what's going to give us the best view of what's happening here. Yeah, the lip readers are definitely going to be out on this one. Really, no question in my mind about that. So his hands are free. What that suggests, one of two things going on. Possibly his ankles are shackled. He might also have a stun belt on. We didn't, get to see him come in or out, so we don't, see how his clothing is sitting or whatever. But that's a fairly common restraint for somebody in a courtroom under settings like this. Seems to be, communicating perfectly well with his lawyers. Rather this not be at an angle where we might be able, people are going to be trying to figure out what they're saying. But it's kind of always one of the things I look out for more than like, expressions and stuff like that, or just big picture things. Does he look like he's getting along with his team? Does there seem to be conflict? These can kind of be some big clues about what's going on, how things are going behind the scene, what to expect, and stuff like that. I can just tell you, you know, from my personal experience, represented more than my fair share of murderers. And I got to say that murderers, by and large, tend to be disagreeable people. And it makes sense. You kind of have to be if, you know, you're willing to be so unpleasant as to take somebody's life away. So it's just kind of one of the things I always look for to try to get a feel for how well are things functioning. Not that we would always know, of course. The court is kind of an artificial environment that way. Got a few new members coming through while we're waiting for the judge to get here. Thank you guys. Appreciate you joining us. Here we go.
Please be seated. Court is now in session. Counsel, if you could enter your appearances, please.
Your Honor, Christopher Ballard, Ryan McBride, Chad Grunander, and Lauren Hunt on behalf of the state.
Good afternoon.
Good afternoon, Your Honor. Kathy Nestor, excuse me, Richard Novak, Stacy Visser on behalf of Mr. Robinson.
Good afternoon.
Good afternoon, Your Honor. Jeff
Please be
Hunt
seated.
and David Ryman appearing on behalf of the media interveners that are identified in our motion papers.
Court is now in session.
Michael Judd, Your Honor, Parsons, Bailey, and Latimer,
What is
on
going
behalf
on
of
here?
another set of media interveners also identified in the briefs.
Good afternoon.
Hang
Counsel,
on.
if you could enter your appearances,
Mr. Robinson
please.
in the courtroom as well. Good afternoon.
Your Honor,
I'm,
Christopher
For the
Ballard,
record,
Ryan
calling
McBride,
case
Chad Grunander,
251
and
Echo
Lauren
here.
Hunt
3
on behalf of the state.
576.
Good afternoon.
State of Utah
Good
versus
afternoon, Your
Tyler
Honor.
James
Kathy Nestor,
Robinson.
excuse me, Richard Novak,
Counsel, as
Stacy
we're moving
Visser
forward
on
today,
behalf
I
of
want to
Mr.
give an
Robinson.
overview of what we
I don't know why we're
anticipate
getting
doing.
two
Good
audios.
afternoon, Your Honor.
And
Jeff Hunt
It
and
comes
David
down to
Ryman
addressing
appearing
three
on.
This over here. I don't know why we're getting two audios, guys. Let me go back. Let me just go back. I'm going to restart us here.
3 576 State of Utah versus Tyler James Robinson. Counsel, as we're moving forward today, I want to give an overview of what we anticipate doing. And it comes down, we're addressing three issues. The first is the October 14th, 2025 audio recording of the closed hearing and the October 24th, 2025 transcript of that hearing. The second is the state's motion to amend or clarify the publicity order, commonly known or referred to as the gag order. And finally, the motion for limited intervention and request for notice of motions to close, seal, or reclassify, and which has been filed by the media organizations and by counsel who are present today. So as we begin, the first part is we'll begin by addressing the October 14th audio recording and the October 24th transcript. This portion of the hearing will be closed so that I may hear from the parties regarding which portions of the recording, the record should remain sealed. All members of the public and the press will be excused, and the hearing will not be broadcast. This is because I need to hear what should or should not be sealed or protected, and it would not benefit to have everyone listen to what should be sealed. And so after I've heard argument, we will invite all parties or the public and the media to come back in, and the hearing will resume transmission. We will then take up the motion for limited intervention, followed by the state's motion to amend or clarify the publicity order. These portions, the last two portions, will be open to the public and to the press. After hearing argument on all three matters, I will take a brief recess and then return to issue my ruling today. We will then stand in recess. So at this point, we'll go ahead and excuse the public and the media, and it is the court's order that transmission be terminated temporarily.
Your Honor, we have one request with respect to the closed hearing. May I be heard on that?
Yes, counsel.
Thank you. Richard Novak for Mr. Robinson. Mr. Robinson has some immediate family members who are present, his father, his mother, and his brother. And we would ask the court to permit them to remain in the courtroom during the closed portion of the hearing.
To the state.
My only concern with that, Your Honor, is that we're going to be talking about court security measures. And I don't know that we'll have to go into a lot of detail about that, but I do have concerns about those issues being discussed in public.
All right. Mr. Novak, do you have authority that supports allowing them to remain in a closed hearing?
No, I think it's subject to the court's discretion to decide who is and is not an appropriate member of the public. I think they have a unique relationship with Mr. Robinson, and they would certainly abide by any orders the court makes concerning disclosure of what is discussed in closed session. But obviously, it's up to the court.
Thank you, Mr. Novak. I'm going to rule that they will be excluded as well. It is just given the nature and the sensitivity of it. I believe it is appropriate to treat all parties in the public equally, though I do recognize their relationship with Mr. Robinson. Thank you for your request. All right, we will go into the closed session. Thank you.
So we are going to get booted out of court for the closure hearing. So, okay, let me just kind of fill you guys in on what's going on. So first off, we are going to hear more than just, which now we're not going to hear about the transcript, but that was kind of the original basis for us, being called into court in the first place, was to talk about the transcript from the closed hearing, what needs to be redacted and what doesn't. But like I had pointed out at the top, there's been this other stuff going on in the background, particularly, surrounding the gag order is one of the more interesting parts. And then the media asking for recognition as party interveners, giving them a certain, standing in the case to be able to participate in a limited way on issues relating to public access. So we are going to apparently hear about those. Which is good to know and interesting. The gag order in particular. Yeah, I'm going to be excited to see where we end up going with that. I can show you guys. I will just pull up because of course I've got it over here on the Substack. Just have to find it. What those motions are. Just give me a second here. Here we go. So let me switch over and share that instead. Here we go. This is the motion to amend or clarify the court's pretrial publicity order. And what they're basically doing, they have a pretty good introduction to this motion, but they're just essentially saying, here is what the order specifically provides. Lawyers participating in the investigation or litigation of this case shall inform all witnesses of the prohibitions. And it applies specifically on its face to lawyers participating in the investigation or litigation of the case. So this has been the subject of an awful lot of like confusion and discussion and stuff like that about what exactly this gag order does. Who does it apply to? What are the consequences of violating it? And I want to be crystal clear that the way that the motion is written so far, the way that the order is written so far, it does not directly apply to witnesses. Witnesses are not going to get in trouble if they say anything about the case. The issue is that it's worded in this way that kind of suggests the lawyers might get into trouble if the witnesses say stuff about the case. And so naturally, the lawyers are a little bit concerned about that because they're like, I don't necessarily have control over whether, an eyewitness from the scene or something like that decides that they have something to say. We've seen, for example, Erika Kirk has given a couple interviews at this point. She hasn't, as far as I've seen, given really any detail about the case or any information she's been provided or anything like that, but certainly a risk. Other folks associated with TP USA, have had some things to say. There's been a lot of, questioning about them. They're in a kind of this awkward position where, we don't really want to jeopardize the case, but we kind of also need to defend ourselves against these accusations that are out there. So it's just creating a little bit of muddiness as far as what are the lawyers actually required to do, and what is this gag order actually intended to accomplish? And part of the problem with that is because this was just done ex parte by the court. They didn't have a hearing on this. Nobody filed a motion for it. It just kind of came down. And so the thought process behind why this is necessary, what are the actual risks that we're trying to prevent against, and why does this necessitate what is an extreme remedy in the United States against the First Amendment, shutting people up, requiring them to not be able to speak on issues that they might want to speak about, particularly issues of public interest? We don't know. We don't have the context to be able to understand that. So they had this initial hearing back in September of this year where they asked for clarifications. Who are we even dealing with? If we're required to notify witnesses, does that mean literally everybody? Does that just mean people that we anticipate putting on our witness list? It's not entirely clear, and it doesn't sound like the court necessarily made that. It didn't really resolve that confusion all that well. So they're still required to follow the order and inform witnesses of its prohibitions as the lawyers identify those witnesses. Doesn't really answer the what and the how and what they're required to do and so forth. And so even with the modification, it leaves open the possibility that it's meant to apply to any potential witness, not just those who are members of the teams, who you would be expected to have a lot more control over, right? If you don't want my expert witness out there giving interviews to the press, I can have some control over that because I have a contract with that witness, and I can put an NDA in my contract with that witness. And frankly, if I'm a lawyer, I have probably already done that anyway, because you've got confidentiality considerations with that type of thing. It's work product. It's privileged. So I have control over that type of witness in a way that I don't really have control over, somebody from TP USA who was there, who wants to say something about it. I don't have the power to like jump over my table to wherever they happen to be and put my hand over their mouths. Like, not really clear what the lawyers are supposed to do in that situation. So the state's arguing, if that's the case, that it's meant to apply broadly, then it is not supported by the law. In other words, the court has not conducted the requisite legal analysis and made the findings necessary for a prior restraint on speech. It is also likely void for vagueness, and to the extent it is meant to apply to witnesses not subpoenaed to testify, it is overbroad. This is because anytime the court is going to shut down content-based speech. It's going to censor you and your ability to speak based on what you might say. It has to meet strict scrutiny. And so what that means is that they have to identify, here's a compelling government interest that justifies us doing it in the first place. In the court context, the criminal case context, they will typically always find it's the right to a fair trial. The right to a fair trial, yes, is extremely important. A right to due process, right to an impartial jury. These are rights of constitutional magnitude, and the integrity of what's happening in a criminal case really depends on those things being honored. So to the extent that people talking has the potential to jeopardize that, it is going to justify some type of restriction on speech. But the issue is, under strict scrutiny, it has to be narrowly tailored, okay? What you shut people up from, it has to be very specifically focused on what is the harm that we're envisioning? How is this particular speech going to jeopardize that? And how are we making sure that we're not extending this prohibition? We're not making people censor themselves far beyond what is necessary to just achieve this goal of making sure that he gets a fair trial. Because we can imagine, just even in the context of a case like this, there's quite a few different levels of prejudice, that might result from people having something to say. Somebody who was, there at the time, that he turned himself in or spoke to him or the parents or something like that, that person talking about the details of what happened, that has the potential to be significantly more prejudicial than somebody who was just there on UVU campus that day, saw what happened, saw the chaos, doesn't have any personal insight into the investigation and what happened or what didn't happen. And so how can we be sure that, since that second one is really not likely to impact a potential jury pool in any way, that person isn't chilled? They're not worried about, what if this order applies to me? I could be thrown in jail for contempt or something like that. So I'm just going to not speak. That is not allowed under the First Amendment. You have to be very narrowly tailored, and you have to be very clear about what these restrictions are and who they apply to, so that you don't run into this problem of it's overbroad, and so people are not saying things that they have a right to be able to say. The First Amendment is grounded in a fundamental principle that more speech is better, and that 99 times out of 100, the marketplace of ideas is the remedy for bad speech, for people saying things that we don't like, or that we don't want to hear, or that we think might be harmful. There's certainly limits, exceptions to the First Amendment, but they are very specific. Your things like your incitement, your defamation, your true threats, stuff like that. So if it doesn't fall within one of those categories, which generally, talking about your experience, on UVU campus isn't going to do, then you have a right to say it. And the First Amendment jurisprudence suggests there's a value to you in contributing to the public discourse on issues that are of interest. So essentially, they're saying, look, we're trying to do our best, but if it applies even to potential lay witnesses who are not members of the prosecution or defense teams, then it restricts the free speech rights of citizens without adequate due process, and it's too far-reaching and vague for the state to effectively comply with. And where sanctions for noncompliance by a witness could range from mild, for example, contempt of court, to severe, the state asks the court, wait for a motion. Like, you should have maybe let us argue this. You should have maybe had somebody ask for this, and see what their reasoning is, and develop some actual basis for what are the risks here. What's the jury pool? How many people are even paying attention to the details of this case? It comes up a lot with pretrial publicity and concerns about it, because when you're real close to the case and you're following it real closely, it's just kind of natural for people to assume that other people are also paying attention. And there certainly are, but probably nowhere near as many as you think. There's a lot of people who have zero interest whatsoever in criminal cases. No interest at all. you know, might have registered with them that Charlie Kirk got murdered, and that's about it. Like, that's the extent of their interest. Other people might be more interested in it, but are not particularly concerned about the ins and outs of the court case. So they don't follow the details. You know, they just wait for like the big picture headlines that come through, and they have, you know, more or less interest in those, and they retain those, you know, to a greater or lesser extent. So this is the reason why normally you need to have some kind of evidence. You need to have some kind of hearing, some kind of evidence to justify entering a gag order, because you need to know what you're dealing with in order to make sure, you know, number one, yes, there is a legitimate concern here. There's, you know, certainly lots of people are watching this case. Probably a good chance a lot of people in Utah are watching the case. Might be helpful to know like what the opinion is if we've got some type of polling or something like that. If we've got some type of analysis of what the reach is, the intrusion of some of these stories and some of the alleged facts and stuff like that. How widely have they been distributed within this area that is going to be the potential jury pool? A lot of those questions, like we saw in Koberger when they were doing the motion to change venue, have very, you know, similar implications when it comes to things like, do we need a gag order to be able to protect people's rights? We need to know how many people are paying attention to the case in the first place. So the state's arguing it should, if it applies to witnesses at all, it should only apply to prosecution and defense team witnesses. It should not apply to like anybody at all. And this is that reason. You don't have control over them. You know, to make me responsible for what somebody else might say is to put an impossible burden on me. I don't have the ability to make people speak or not speak. Citizens have the right to free speech. Yes, they do. That is absolutely the starting point. So they, you know, are going through a lot of the case law on this. We looked at a lot of this case law in my live stream on the gag order as well. They're arguing it's too vague. If you don't know exactly who it applies to, you have a problem, because anybody that is close to the boundary, they have that incentive to shut up and not say things that they might otherwise have the right to say, because they're going to be concerned, I could get in trouble for this. It's not even clear if it applies to me at all. But I don't want to guess wrong, you know, and find myself in jail. It's a very normal reaction for people to have. But that is not tolerated under the First Amendment. So then he's also arguing it's overbroad, because we don't know what the necessity is. We don't know what the perceived danger is. And so applying it to any and all witnesses is creating the risk that people who have information that's not going to materially prejudice him at all, but it just happens to be, you know, stuff that they know, might be called as witnesses. I got an example for you. Erika Kirk, she's likely to be called as a witness. She's certainly going to be called during the penalty phase, if nothing else, but potentially also during the guilt phase, because it's pretty normal for the state to put on, like, here's what his last day was like. You put it in context. Here's the circumstances that led up to the shooting. Here's his background. Here's who he is. Here's, you know, what he did for a living, so on and so forth. Is that stuff going to be prejudicial to Tyler Robinson if she says that, like, in interviews before trial? It's kind of hard for me to see that. But the way that the order is written, if it applies to witnesses, if lawyers can be responsible for statements like that, then it seems like, you know, they're at risk of being penalized because she's saying things like that. But those seem like the kinds of things that are not supposed to be contemplated under an order like this, because they don't jeopardize his ability to get a fair trial. So that's the gist of the state's motion and what they have argued. Now then we have the defense's response to this. Let me make this a little bigger here. The defense's response, it's quite interesting. So they disagree. We do not agree that there's any problem with the existing gag order. It's fine. Satisfies the First Amendment requirements in the defense's view. So they want the motion to denied. They say totally fine because it's directed at the lawyers. Now, this is deriving from the case of Gentile versus Nevada. This was a case that dealt with the extent to which the court can restrict the speech of the lawyers involved in a case. Every jurisdiction in the country has a rule, an ethical rule dealing with pretrial publicity and the kinds of statements that lawyers are allowed to make or not make. And a lot of reasons for it, but the general, idea behind it is they don't want the lawyers litigating the cases in the press. That's what we have a court for. The lawyers are supposed to be officers of the court. They're supposed to be maintaining the decorum of the court. They're supposed to be upholding the integrity of the court proceedings. So they don't want the lawyers out there just, giving your whole case to the press instead of presenting it in the courtroom. So there are rules that prevent lawyers from making extrajudicial statements that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. This is almost identical language to the rule that was at issue in Gentile. The U.S. Supreme Court said that rule's fine. That rule's fine. Now, what was interesting in Gentiles in that particular case, they said this guy didn't violate it. And there were a lot of reasons why that was, that gets cited a lot. But a big one has to do with the time. This gets quoted a lot and brought up a lot in these types of evaluations. The time between the statement and the trial. If the trial is like way down the road, according to Gentile, you can't really say it's prejudicial because you don't know how many people are going to remember it. You don't know how sticky that information is going to be. You don't know if these people who are in the jury pool hearing it are, going to move away and not care anymore, not even be in the jury pool, stuff like that. So the time to trial was a significant factor in that case. They also look at there are provisions in most of these rules, and Utah has this type of provision where even though you have this restriction on what is generally speaking intended to encompass showing your evidence, giving your evidence to the press, making your case to the press, there are exceptions for responding to pretrial publicity that you didn't cause. And this comes up a lot, in my view, in criminal cases, because that's what happens 99 times out of 100. You have this massive, information dump, particularly with a high profile case, when you have an arrest and a charge and you have the entire, state's theory is everywhere. And that's what you get to hear. You hear, here's who we got. Here's what we charged him with. Here's the evidence that we had that, or that we say that we had that justified us taking this step. And so, then a gag order comes down and the defense is just, they got to shut it. They never get to counter that. The rules contemplate that they potentially can counter that. So we saw that, for example, in the Richard Allen case. Those of you guys who followed that, the defense attorneys, once they got appointed, they issued a press release, and they responded pretty specifically to some of the allegations that had been made against them. So that got them in some hot water. Court didn't like it. State didn't like it. Heaven forbid that the public get a contrary point of view. The public might get the idea that there's an actual defense here, right? Can't have that. But what they did is completely legitimate under most of these ethical rules and under the reasoning of Nevada versus Gentile. And at the end of the day, you know, they dealt with a lot of hassle with that in that case in terms of the court, but they never got in any kind of like ethical problems with it because there weren't any ethical problems with what they did. So the defense again is just saying, you know, this tracks the existing, tracks the existing ethical rules that the lawyers are already subject to, imposes a duty on both counsel for them to take reasonable care to prevent others associated with their respective teams. It does not purport to specifically order non-attorneys to limit their speech. Okay, so even the defense is agreeing this order does not apply to witnesses. As it's written, it only applies to the lawyers because only the lawyers are subject to the rules of professional conduct that this order is encompassing. Non-lawyers don't have to follow the lawyer's ethical rules. And so according to them, you know, it's totally fine because it's only the lawyers who are potentially jeopardized by this order. And it's fine because all the order is telling them to do is to, follow the ethical rules that they would already be subject to. I don't particularly agree with that characterization of what the order is doing. But that's generally the argument that they're making. So they're just saying, you know, counsel is on notice that you have a duty to not do things that could jeopardize his right to a fair trial, which of course is completely legitimate. The question is, does the order clearly, unambiguously, not overbroad, actually do that? Now, here is where we have the interesting footnote to the defense's argument here. Just going to read it out. Mr. Robinson also intends to file a motion to modify the order, but will do so separately from this response to the state's motion to amend. As his motion will explain, it is Mr. Robinson's view that the order should go further to limit the public statements that may be made by federal, state, and local government officials, some of whom are attorneys and some of whom are not, connected with the state and federal investigations of the conduct alleged against Mr. Robinson and their agents. His motion will also ask this court to amend the order by explicitly invoking Utah Rule of Professional Conduct 3.8, which established special responsibilities of a prosecutor with respect to a broader group of attorneys and their agents. The publicity order issued on September 16, 2025 does not invoke Rule 3.8. Prosecutor's specific rule. Additionally, Mr. Robinson does believe that the publicity order should be expanded to specifically limit the extrajudicial statements that may be made by persons associated with the prosecution, including potential lay witnesses, and that could be enforced if necessary through contempt proceedings directed at those persons. Wow, the defense potentially wants to throw witnesses in jail for speaking. That's kind of wild, honestly, kind of wild. Want to throw people in jail for speaking. Mr. Robinson's motion will be filed so that it may be fully briefed and submitted in advance of the hearing scheduled to occur in this matter on January 16th and 30th, 2026. Mr. Robinson respectfully suggests that both motions be heard at the same time. That is clearly not happening, or at least I guess it remains to be seen. The judge says we're going to talk about the state's motion to modify the gag order. Doesn't necessarily mean we're going to decide it at this point. He could just, you know, address this and decide that they're going to kick it down the road. But the defense, you know, got this big footnote. They have not actually filed this motion yet. And I have to tell you, I am waiting with bated breath for this motion to drop because there's so many problems with this idea straight off the bat. Like, forget about, wow, you defense lawyers want to put potential lay witnesses in jail for talking about what they know. Are we talking about Erika here? That's really what I'm are we talking about Erika? You want to put Erika in jail for giving interviews? Is that what this is? I don't know, but that certainly is going to be contemplated by giving the defense what they want. I understand the defense's job here is to look out for Mr. Robinson's interests above anybody else's. Okay. And if other people have to go to jail to do what they think is right for Mr. Robinson, then that is what they're going to push for. But I also just got to point out that this, I mean, you want people to shut up that bad. You want people to shut up that bad. It's because you're anticipating they got some, they can do some damage. They got some things to say that are not remotely helpful to your position. You are scared of what they have to say. That's why you have to shut them up. So that really stands out. But then also federal, state, and local government officials, they seem to want a state court judge from Utah to gag Pam Bondi. That seems to be what they're saying they want. Federal was not dropped in here by accident. They have complained about Pam Bondi's statements before. They've complained about Kash Patel's statements. They've complained about Donald Trump's statements. Surely they're not talking about the president of the United States having to answer to some state court judge in Utah, because that is, of course, ridiculous. But even Pam Bondi, for example, you have a supremacy clause problem with the very idea that a federal official is going to be subject to the orders of a state court. This comes up routinely. We've dealt with this in many of the cases we've looked at here. This is the same problem that you run into when you try to, say, subpoena the FBI's file or compel an FBI witness to come into court to testify about details of their investigation. They don't have to comply with state orders. There's abundant case law on this. The supremacy clause means the federal government gets to decide when and if they are going to show up in state court on any issue. And so that's why we have the whole TUI process that we have to go through when you're in state court. And I mean, this happens so often. This is like routine that you have some arrest that comes from like a task force. Task force is often just made up of kind of all kinds of different people from different law enforcement agencies. You'll have some state patrol people. You'll have some local police. You'll have some sheriffs. You'll have some FBI. You might have like DEA, other agents, things like that. And so, they'll do a task force investigation and everybody's written their report and everybody's kind of, done their certain part of the process. And you, the defense, think, hey, something that the feds did here might be helpful to me. Because the feds aren't, the state's not calling them on the witness list. I want to get their stuff. I want to find out what they did. I want to get their report because you don't have it in discovery because they never gave it to the state. You will find yourself enmeshed in the TUI process, trying to get a hold of that report because they don't have to give it to you. They get to decide for themselves what the rules and regulations are for when they're going to share their own files, their own investigative materials, when they are going to make their own employees subject to the jurisdiction of your state court. So if that kind of restriction applies to low-level line agents that are like actually working cases, actually doing material things in the course of an investigation, it is absolutely going to apply to Pam freaking Bondi. Okay. She's going to immediately, let's say this gag order gets signed the way that the defense seems to want it to be. And Pam Bondi goes on Fox News and gives an interview and she says all kinds of things about Tyler Robinson, about the case, maybe some things we haven't heard before, maybe recaps of stuff that we already know, and who knows. And so she's in contempt of this order that's telling her you got to shut up. So what happens? How do you enforce that? Well, the judge or the prosecutor has to issue a contempt citation to her. You got to compel her to come into court. So, some cop, I guess, maybe shows up at the DOJ in Washington, D.C. with an order saying show up in court in Utah, in Provo, Utah on this day and time and explain why you shouldn't be held in contempt for the statement that you made. And what Pam Bondi is going to do is what the what the line agents do, which is go immediately to your nearest federal court and move to quash it under the supremacy clause. And the court is going to say granted. And you are now going to have a federal court order for Pan Bondi saying you don't have to go to Utah. You can ignore that thing over there. They have no jurisdiction over you. They have no authority over you. So I await with bated breath what on earth the defense argument is here for how this is even remotely feasible within the legal framework that already exists on these types of issues. I imagine maybe this is a little bit of a struggle because, as you can see, this was filed by the defense. Scroll all the way down to the bottom here on the 20th of November. So it's been about 3 weeks, right? It's been about 3 weeks since they said they were going to file this motion. They haven't filed this motion. They filed plenty of other stuff about like the law says the media shouldn't get to be party interveners or why ever that matters to them at all. But this thing that does seem to matter to them, they have not rushed to file. And I have to wonder if it's maybe because they're finding it a little bit more difficult to make that case than they thought at the time that they wrote that footnote. So that's where we were, was right here. And that's on the horizon. That's on the horizon. Wait and see, stay tuned. Maybe they'll follow through, maybe they won't, but we'll have to wait and see. So they're also arguing we didn't need to have an evidentiary hearing to kind of establish what the risks are and what type of restraint might be needed to protect his right to a free trial, because we've already got a big record that there's all kinds of press, all kinds of public interest. And so they're just going through and outlining, what a lot of this is that's already come up. This was kind of there's a fun comment somewhere in here. Maybe I'll be able to find. I forget exactly where it was. But basically the grifters. There's so many grifters interested in this case that surely to be accompanied by traditional media and less traditional social media posts. Heaven forbid, the lack of traditional media. And so, if we don't have a gag, then there's lots of people who are going to try to, improve, expand, have new reasons for the public to click on their stuff as opposed to other stuff. I gotta say, I just don't, this is not accounting for what happens when you have the information vacuum. When you don't have any new information, then people speculate about new information and people hallucinate new information. And heaven forbid, sometimes people just make up new information like we saw in the Koberger case. So much just false information coming out because nobody gets to talk and we don't know. And nobody can even come out and say that's not true because you're under a gag order. So, normally that type of thing would be, would be bad. You wouldn't want that. But you have to wonder if in this case, it's because that environment is kind of helpful to the defense. Having a lot of people, speculating about what the investigation did or didn't do, what materials, what evidence they have or don't have, brainstorming all kinds of ideas about, defenses and alternative theories and stuff like that, might kind of be helpful to them in a few different ways. One, you're sort of focus grouping things that could lead to reasonable doubt, right? You basically have a free opportunity to sort of gauge, hey, this argument was made, and here's how well it resonated. It's been picked up. It's been repeated. This seems to be something that people sink their teeth into. And so maybe this is an area that we explore as the defense team to see if we can come up with a way to integrate this into our court defense. But also just because even if there doesn't end up being anything materially helpful to the defense that they could actually use in court, it nevertheless you know, kind of does serve that even the playing field objective a little bit in the court of public opinion, in the media. If you have a lot of skepticism and you have a lot of distrust and you have a lot of just kind of flat negation of the case, and not a lot of focus on what the evidence is and where we're at in the process and how things are going to unfold and stuff like that, well, then that, you know, creates a possibility that people are going to the extent people are going to form fixed opinions early on in the case that might make them, you know, not very good jurors. It just kind of increases the possibility that some of those fixed opinions are going to be, you know, pro innocence. He absolutely didn't do it. I don't care what kind of, you know, evidence they try to present me. I don't trust the FBI, you know, whatever, stuff like that. So, it's just very interesting to see this unfolding the same kind of way it unfolded in Kohberger, but in going in such a different direction, right? Where you have the information vacuum, you have all of this flurry of activity to fill it. In Kohberger, it was all of this guilt confirmatory stuff, so much of which, you know, again, turned out to not be true. He was not stalking the victims. He did not have their driver's licenses in a sock in his car or in the, you know, in the bedroom or things like that. Just these things that got picked up and seized and magnified and just reinforced this narrative of like, he's super guilty before we even get to a point of seeing, you know, more evidence than what they had in the probable cause affidavit, which was pretty marginal, pretty thin. This case really different. Same vacuum, same like generating stuff to talk about and think about, but very much not guilt presumptive. Very much, you know, frame job presumptive. So I don't know why that is, but it just has been very interesting to kind of see that unfold. So this is just their, you know, like I said, they're talking about the scope of the publicity is already well established. We don't have to have a hearing about that. So we already know basically that if somebody gives an interview, it's going to get picked up and it's going to be covered and it's going to be all over the news and everybody's going to talk about it and there's going to be derivative content about it. The grifters are going to get on it and all that stuff. What they don't really get to though is the actual impact that is likely to have on the jury pool. On the community, specifically, you know, these people right here in Provo who are going to be summoned in. Are they even paying attention to any of this? Is this even being delivered to them? How many of them care? What sort of processes do we have in court to be able to weed that out anyway? You know, again, publicity in court cases is not new. This is not the first case, you know, that's ever been blown up on a big national stage. The media in their brief that they just filed on why they should get to be interveners, they make this point extremely well. Like every time there's a high profile case, people act like it's the first one. And like courts haven't had to deal with this since as far back as like Sacco and Vanzetti and the Lindbergh baby and stuff like that. Like this is not a new issue. Courts have dealt with this for a long time. And so they already have their own mechanisms that they've developed to, you know, sort out how do you deal with that. And the big one is jury selection, voir dire. Now, definitely like a lot of issues with that in terms of the kind of disconnect between what the law says the rules are. The law says that this is an adequate remedy to just ask people, well, are you going to be biased by what you read about the case? And people will say, no, I will not be biased. Well, it's not really helpful, is it? Because there's a lot of psychological stuff that goes on kind of, you know, behind the curtain that we're not even necessarily aware of when we get exposed to information and, you know, we develop preconceptions and we, you know, make associations and connections between things without even necessarily paying attention to it or being aware of it. And of course, everybody has a bias in their own favor. Everybody thinks, well, of course I can be fair. And so everybody is going to say, if you just ask them, well, can you be fair? And like judges literally do that. They're just like, well, can you be fair? Oh, they said they can be fair, therefore they can be fair. It's like, no, everybody's going to say that. The only people who say, no, I can't be fair are the people that want to get off the jury and are going to, say something like that anyway, like something to warrant them not being selected in the first place. So, I mean, we can certainly debate all around and back and forth about whether, whether that's legitimate and the extent to which it's legitimate. But the kind of bottom line, big picture is that at the very least, you have options to bring in a ton of jurors. Okay. Bring in, if our normal jury pool is, we bring in 60 people to pick a jury of 12, which is pretty average for a normal low-level felony case. In this case, we'll bring in 500. We'll start from there. We'll bring in 500. And out of these 500 people, is it going to be possible to find 12? Let's add our alternates. 16, if it's a long case, death penalty case, and so forth. We're going to be able to find 16 people out of 500 who are not familiar with the details of this case, who have not been following it, who don't read about the press, who don't particularly have opinions about it, who are like, sure, I'm happy to look at the evidence that's presented and decide it based on that. Doesn't really seem that infeasible unless, again, you just have a maybe exaggerated perspective on how many people really care about this stuff and are really watching and really, really paying attention and really noticing a lot of these things. Because, when we care about something, we just naturally assume that other people care. But I guarantee you there are plenty of people who don't care at all about this case. They don't care at all. They aren't paying the slightest bit of attention to it. And so that's part of the jury selection process. It's just find those people and make them the jurors. Is that impossible? Well, sometimes it might be. But you need a little bit more of an evidentiary record to be able to establish that. So then the last thing is, it's arguing is no, this order is totally fine. Everybody understands who it is and who it applies to. I would humbly suggest that might be belied by what I read on social media every day about people's interpretations of the gag order and how it works, who it applies to, and so on and so forth. It really does not appear to me to be that crystal clear and unambiguous. But they're arguing it is, and it's this is clear enough as long as it has a substantial likelihood of materially prejudicing the proceeding. Everybody understands what that means. Everybody understands what that means, and so can censor themselves accordingly. Do you agree with that? Do you agree with that? If you were gagged, if a court put down an order and said you're not allowed to speak. You're not allowed to say anything that you might have a substantial likelihood of materially prejudicing the trial. Do you know what that means? Or are you just going to shut up and not say anything at all? I don't know. What do you guys think? I tend to think it's probably not that clear. It's lawyer speak. Lawyers understand this pretty well. But it's also lawyers' job to argue about what this even means and who it covers and who it doesn't. It's lawyers' job to find ambiguity and stuff. So, if the lawyers can make an argument that it's not clear who it applies to, then probably it's not that unambiguous. And then they're arguing, the state's not helpless here. The state can totally know who their witnesses are. They're just basically saying, as long as you identify who might testify, as soon as you get a name, this person might testify, might be called as a witness, then the obligation is going to attach. That might be the case if the gag order does end up being, allowed to be this broad. Then maybe that would be the case. But again, question is going to come back to does the order need to be that broad to do what it is that you're trying to do to protect his right to a fair trial? Because there is going to be a difference between, witnesses talking about unrelated things, witnesses talking about related but not prejudicial things, and then witnesses talking about things that have the substantial probability of impairing the right to a free trial. So, guys, that's the gag order. That's the gag order litigation. That is what is going on with all that. I'm going to go ahead and bring the hearing back over, just so that we have it here. Still on schedule. Oh yeah, just waiting for them. So what they're doing. I don't think I can. It's going to take me a little bit more time to sort through some of this, but the Idaho Code of Judicial Administration is what sets out what the rules are for sealing documents, for closing documents. They have this very kind of complicated system of classification, like all of these different levels of classification that apply, can apply to different documents, and based on, what they are, and then defining who gets access to them and what kind of, process is involved, and so forth. But one of the parts of this rule is that, you got to have a hearing on it if there's an objection to it, or if there is media is interested in participating, which has been met in this case. So let me see here. Yeah, so okay, here's the, I'll just share this real quick. This is like really difficult to read. I don't know if you guys are going to be able to see this at all, but I can't really, maybe I can. Can I make it bigger? There we go. This is the subsection. So when there are issues, if a press has requested notice in the case for motions involving sealing and classifying public records as private, they have to be served, and then the court must conduct a closure hearing when a motion or petition to close a record is contested, when the press has requested notice of closure motions or petitions in a particular case, or when the court decides public interest in the record warrants a hearing. So this is why we're having this hearing at all, right? Is to basically give the media their opportunity to be heard on this. But of course, we are now having a closed hearing. We are now having a closed hearing. And guys, guess what's going to happen here? Guess what's going to happen? We are going to find ourselves in this like metaverse where we're now going to come back and talk about whether we need to unseal the transcript for this closed hearing that they're holding right now today for this part. And then what, are we going to have a closed hearing on that too? And then have another argument about releasing the transcript on the closed hearing? Like this is it's just getting a little bit awkward from my perspective. I don't know what's going to happen here. He says we got to close it because we're going to talk about security stuff apparently again. But once again, we know they're not only going to talk about security stuff, because some of the proposed redactions that the media is objecting to are not court security related. They're based on these other justifications, privacy and right to a fair trial. And the media has very specifically said those aren't reasons. That's just nonsense. Like you're trying to use magic words to say that justifies it, but we don't even know what it is. How are we in a position to evaluate if there's a privacy interest that needs to be protected? There's something specific that was said that might jeopardize his right to a fair trial. Don't know what that is, but you kind of got to know to understand if there is a basis for this order or not. So the judge is going to decide one way or the other what gets redacted, what doesn't get redacted. Do those reasons, those justifications that the parties have agreed to in their stipulation, am I going to follow those, or am I going to go with the media and say, you know, some of these might not be appropriate, and so we're going to unredact more than what the parties have stipulated to? We're entitled to know the basis of the court's decisions. When the court is making decisions in a case, he's adjudicating rights, including the rights of us, the public, with our First Amendment right of access to criminal court proceedings. We have a right to know what he is basing those decisions on. So I have a hard time seeing we're not just going to end up in this same cycle of, you know, media wanting the transcript of this hearing, this discussion. And then because they had talked about security, you know, at some point at the very, very initiation of all of this, that's going to like continue to follow through, and we're going to seal it all on this justification of got to protect port security. It's messy. It's messy, and it's just threatening this very efficient, not good use of the court's time. How is this a good use of everybody's time? Are we still trying to get prepared for a preliminary hearing here? Isn't there a lot to do? Like, we had a lot of discovery to go through. There's still investigations going on. We're waiting for a defense motion on why the gag order should, you know, threaten to put Erika Kirk in jail and shut up Pam Bondi. Like, shouldn't we maybe be spending our time on that instead of whether and to what extent we get to see transcripts of the basis for the judge's decision about what we get to see? I don't get it. You know, to me, the better way to handle this would be to have our open hearing right here in court where we can all see, and simply instruct the parties that if they are going to refer to anything in detail that they are, you know, concerned about being publicly available, go up to sidebar and have a conversation about it. And let the judge decide, okay, we need to hear that in public, or we don't need to hear that in public. But then everybody at sidebar has heard it, so they're aware. We in the public haven't. It's on record, it's in the transcript. And in the meantime, we've gotten to watch the court hearing. And we don't have to go through this song and dance of trying to get the transcript of what we didn't see. To me, that seems, you know, pretty straightforward and obvious. But of course, I'm not the judge, so what I think doesn't matter at all. Could not be less important because I am not remotely authoritative on this issue. Obviously, confirmation, the families in the courtroom, the defense wanted us all to know that. Wanted us all to know that they're in the courtroom. Maybe we're supposed to draw inferences from that. Don't know what. Again, I expect, most of the time, I expect families to stand by their loved ones in a situation like this, where they need help. You don't, you know, throw away and cast aside your loved ones. It's not a particularly Christian thing to do, I think, because you know, people can be redeemed. It's kind of an important philosophy to have if you're going to have like a criminal justice system at all, right? Like, why put people in jail and then let them out if people are just kind of throw away people from a moral standpoint once they've done something bad. So you know, I don't know what, if anything, we're supposed to kind of infer from the family being present, but they definitely wanted us there. They wanted us to see the family as affiliated with the defense team, right? It's the defense, Mr. Novak, that is standing up and you know, purporting to represent them and their interests. That's suggesting that you know, even though the family is in the probable cause affidavits, you know, pretty solidly in alignment with the states, pretty clear they're going to be called as witnesses by the state. Nevertheless, it's the defense, you know, they're really on the defense side. And so I would just to suggest perhaps to consider that side by side, the implications of that and what that might mean with what the defense is trying to do vis-a-vis this gag order. Okay, if the defense has Tyler Robinson's family so on side that they have information that's beneficial to him, maybe they dispute the state's version of events, maybe they recant what they've said previously, maybe they have new information, whatever. They got stuff that's beneficial to the defense. Aren't you going to want to scream that far and wide? Rather than expand this order such that if they said anything like that, they could go to jail. I mean, it just says a lot to me, you know, who wants people to speak, who doesn't want people to speak, who's afraid of that, who's not afraid of that, who wants consequences for it and who doesn't. If it would be helpful to Tyler, they would want them to have the right and the power, the ability to do that. So it should raise some serious questions, I think, about, you know, whether they have anything to say at this point that is in fact helpful to him. If they did, you wouldn't be trying to shut them up. On. What else to talk about, guys? Good Lord. It's taken a long time. Taken a long time with this this hearing here. I don't really want to mute it because I want to hear it when they go back, just to make sure it catches my attention. I don't like being behind with that kind of thing. Let's go ahead and take the opportunity. See what you guys have been up to in here. I love pussycats. Yay, Queen, love you. Looking hotter than ever. You're too kind. I'm not having my best hair day today, but sure do appreciate the compliment. Got a couple of new members here. Mike C 1967 is gifted 10. Thank you so much for that, Mike. Very generous of you. And Brian Rambles is gifted a membership. Thank you so much. We like seeing the chat turn green. Allie B from Tennessee. Andrea, you are the most level-headed person I know. I am not trying to stir anything up, but I genuinely want your opinion. Do you feel that people like Candace Owens could potentially cause issues with the jury pool? I feel like I've probably said, you know, most of, like, I didn't talk specifically about Candace because I don't watch Candace, honestly. Like, if it ends up in court, it'll get my attention. If it doesn't end up in court, it doesn't end up in court. And like I said, Tyler Robinson has the most incentive out of anybody to explore any potential avenue related to alternative perpetrators, alternative theories, problems with, you know, the investigation, how things were handled and so forth. So if he doesn't bring it up in one context or another, you know, it's gonna say a lot about, like, the viability of this particular theory or information or whatever. And yes, I know that at trial stuff gets excluded. You don't necessarily hear evidence and stuff like that, but there are motions in limine and motions to suppress and things like that that happen in the court process where you learn about it, right? If somebody wants to present a theory involving, I don't know, Egyptian planes, then there can be motions to admit that, pre-admit that, make sure that it's okay. If you've disclosed it in discovery and the state knows you're not going to go there, there might be a motion to exclude that. So there will be a record of these types of things coming up, whether they're ultimately allowed to proceed with it in court or not. And you get typically, these are, again, high level attorneys. So I expect, pretty good performance on these issues, but you expect an offer of proof. What exactly is it that you want to be able to present? And what's your legal argument for why it's admissible, why it's relevant, what it's helpful for? Why does the jury need to hear this? And then the judge makes his ruling based on it. So even if it doesn't end up in trial, you'll learn about it in court. So if you don't learn about it through a motion like that, you don't hear about it at trial, you need to be suspicious that there's no there, because this guy with his life on the line is the most incentivized to go down every single possible avenue like that there is. As far as a jury pool in general, again, like this case is maybe a little bit unusual. Like I said, where the information vacuum is generating a lot of pro innocence, pro like cover up types of attitudes, which is just, it's not common. Can't say I see that a lot. It's not unheard of. It's definitely not unheard of. But it's not the normal course of things in a criminal case. Most of the time, the press and the narrative and the secret information and so forth, like all of that, it tends to go towards guilt. So I mean, that is prejudicial? I mean, it's not wrong for people to presume innocence. It's definitely not wrong. There's an argument to be made that, yeah, everybody who comes into the courtroom, prospective juror on the case, should be, firmly believing he's innocent. Because that's what the process calls for. You start from the standpoint he's innocent until the state proves it in court. State's got to put up. The issue is when people are closed to new information. That's really what you're searching out, and what you're needing to eliminate during the jury selection process. That's the risk from the pretrial publicity. Candace is one, but there's plenty of conversation. That's the risk, is that people form opinions that they won't reconsider. They won't incorporate new information. We're sort of, as a species, notoriously not good at that type of thing. There's lots of studies about how, once you formed an opinion about something and you're presented with conflicting facts, what does it do? Do you stop and reconsider your position? No, people will just entrench themselves even further. So that's the risk that you're dealing with, is not like, do people form opinions about the case? It's, do they form opinions that are so fixed that they will not be able or willing to revise their opinions when they receive new information? And frankly, I think we're likely to get a preview of this and the scope of the risk that this entails in the case when we get to the preliminary hearing, which is likely going to happen in the early part of the new year. Would have happened earlier, except the defense had asked for more time to prepare, because there's a lot of discovery to review. They have the right to, of course, cross-examine witnesses. They have the right to present their own witnesses at a preliminary hearing. So they need to do at least some kind of preliminary prep before they're in a position to be able to meaningfully address the evidence in the case and the basis for probable cause. But that's going to be the first real public vetting of the case and the evidence. And so, a lot of people have opinions about the investigation and the facts and the evidence and so forth. And I'm not entirely clear what a lot of that is based on, because there's not very much that's public so far. And if there is one thing that I think just about every trial lawyer learns at some point in their career, prosecution or defense, it's the same thing that pretty much every boxer is going to learn at some point in the ring. Stay humble or be humbled. Okay, you will learn what you don't know. You will learn what you don't know. I don't know how many stories I've heard, how many times I've seen somebody stumble in court, make a critical misjudgment about what they thought the evidence was, or what they thought somebody was going to say, or what they thought they were going to be able to establish. And then they get pantsed right in front of the jury. And that's with the lawyer who knows all the stuff behind the scenes that we don't know. The lawyers have the discovery. They got the whole file. They know exactly what's been happening. And so they're in a position to prepare for, the anticipated unexpected. But we don't even have that. We don't even have that. We have no idea what we don't know. So I think that, there's going to be a good gauge for that at the preliminary hearing, because then there will be a massive public airing of what the evidence in the case is. And then we will see how do people react to that? Do people get more entrenched in like, it's all fake, can't believe it, it's planted, yada, yada, whatever? Or do people, maybe begin to question, hey, perhaps I didn't know as much about what this case is based on as perhaps I thought I did, perhaps I assumed I did, perhaps I was told by people that I trusted. I don't know. I think it's going to be a real phenomenon. So thank you for that comment. I appreciate it. I do, try to be level-headed. I'm a lawyer. We have to deal in reality. See, the thing you learn real fast as a defense lawyer, that juries are going to think like normal people. They're going to react to evidence like normal people. And so you better be prepared to argue about the evidence reasonably, because they're not going to necessarily follow your flights of fancy about what the evidence should be, or hypothetically what it could be, or how somebody might be lying without like necessarily proof that they are, stuff like that. I mean, there's always possibilities that the defense can argue, and in a lot of defense work, that's really what it's based on. We're looking for reasonable doubt. So I'm looking for possible alternative explanations for this evidence that the jury is seeing. If I can present to you a plausible alternative explanation for why all of this evidence is the way that it is, but it's consistent with my client's innocence, then that's my case for reasonable doubt to you, because the state hasn't disproved that this is possible. And if this is reasonable, then that's reasonable doubt, and that means you acquit. But it's got to be reasonable, doesn't it? It can't just be, well, but somebody, I don't know, somebody could have planted something. Well, do you have any evidence that they did? What is the reason that we should think that's more likely than the alternative? what about the circumstances make us think we should reach that conclusion? And just by and large, juries tend to give the witnesses and the evidence the benefit of the doubt. They tend to assume that people are coming onto the stand and testifying in good faith. They tend to assume that the evidence is sound unless they have a reason to call that into question. So, you learn very quickly as a defense lawyer that you can't just spin some random thing out of thin air and just conjure up a possible alternative that there's no reason for them to particularly believe is the case. They're not going to buy it. They're not going to buy it. You got to talk to them on the level of what they're dealing with, evidence-wise, real-life experience-wise, reality-wise. And if you don't have that, you don't have an explanation for the evidence, then number one, sometimes your best option as the defense lawyer is to be really encouraging your client to take the deal and not take this thing to trial in the first place, because it's not in their interest to do that, because a reasonable juror is going to look at this and we can predict what a reasonable person is going to think about it. If we can't do that, we're not very good lawyers. If you can't put yourself in the shoes of a juror, see both sides of what you're trying to argue, and predict how they're gonna handle that, then you're not going to be a very good lawyer. Gingerpuff 764, Andrea, love your coverage of this case. Well, thank you. Appreciate that. Appreciate so many of you guys joining me here for it on this rather uninteresting day so far on this rather obscure type of legal topic. But that's what I do. I'm interested in the court case. I'm not really interested in the noise. I'm not really interested in the politics. I'm not really interested in the sleuthing and stuff like that. I mean, like I said, if there's anything there, the parties are the ones with the most incentives to present it, because that's exactly why our system is set up as an adversarial system, so that each party is motivated to bring the best argument, best evidence that they have to support their position. So, it doesn't mean that the process is perfect by any stretch of the imagination. But I'd argue it's pretty darn good. A lot of the time, it's pretty darn good. We got D Rover is a new member. Welcome, D. Oh, hey, guys. Look who's here. Gus has come to say hello. The kitties have woken up from their nap. I'm going to play it by ear here, but we are well into the teenager stage now. And so things get a little wild at times. I might have to pop myself away for a second and lock them out if they start going a little bit crazy. But Gus is usually pretty well behaved. He's the lap cat. He likes to just hang out. So we'll see how long the guys can hang. Shelley Anderson 3010. What do you think of the judge in Minnesota that the jury found client guilty and she overturned the jury? Love your kitties. Mine is 8 months. I haven't seen this case. If you got a name or a link you want to send me to, shoot it my way. There's a variety of reasons why this happens. Sometimes it's like technical legal issues. Some crimes have very specific elements, and it can be easy sometimes for a prosecutor to just go through the case and kind of forget to raise one. And I'll give you an example. I had a case that I handled on appeal where The defendant is accused of attempting to elude a police officer. He ran from the police in the car. And in Washington, our statute for attempting to elude has all kinds of technical requirements. It has to be a uniformed police officer, has to be in the patrol car, marked patrol car, has to be equipped with lights and sirens, has to have signaled the defendant to stop. Lot of very specific things that need to be shown. In this particular case, prosecutor just forgot to ever ask if he was in uniform. Just forgot to ever ask if he was in uniform. So they didn't meet their burden. They didn't have evidence of this particular element of the charge. So the jury convicted him because the jury, I guess, wasn't really parsing the statute that specifically. And it got up on appeal, and I raised it, and I won on that because there's not sufficient evidence. You didn't prove the crime. You gotta prove each and every element of the crime. So it could very well be something like that. There's just something that they overlooked or failed to prove. I really don't know. I don't know the context of this particular case, but I will say just that things like that do happen. It's not not super common, but it isn't totally unheard of either. Objection, y'all. Honestly, I think people just don't like people telling them not to speak, and they don't trust the government. Well, these seem like pretty reasonable positions to me. Oh, hang on a sec. These seem like pretty reasonable positions to me. Like, of course, nobody wants to be told to shut up. How condescending is that? And who do you think you are? How arrogant is that? Who do you think you are that you have the right to say if I should be talking or not? I'll decide for myself if I think what I say has value, and the marketplace of ideas will decide. That's what America is based on. So I don't disagree with this perspective whatsoever. I feel like it's kind of un-American to trust the government and just be totally on board with people telling you not to speak. Gringo Tomato 1117. Do you take the deal if you did not do it? Well, boy, is this a Pandora's box that you're opening up? Yes, guilty people will plead guilty or innocent people will plead guilty when they are at a risk of being convicted, and the consequences of being convicted are great. This is certainly not unheard of. The thing is that there's usually some ways to account for that in the process. You have, for example, the Alford plea. Alford plea is based on North Carolina versus Alford, U.S. Supreme Court case from back in the day that basically says, yes, innocent people can plead guilty. You're allowed to enter this special form of a plea where you say, I am not conceding that I committed the crime, but I'm recognizing that there is a risk that I would be convicted if it went to trial. And so I want to accept the benefit of, whatever bargain the state is offering me, or the government, whether you're talking about the feds or the state. So there is a mechanism that exists under the law for people to do exactly this. Be not guilty, but be like, look, they have so overcharged me, for example, that the jeopardy I face is so bad that I can't take the risk. And unfortunately, that's kind of built into a lot of how our system operates now. We have a system of guilty pleas, far more than we have a system of trials. If everybody who wanted to contest the government's case went to trial, we wouldn't have enough courtrooms and enough time and enough jurors to be able to do that. We have a massive volume of criminal cases going through our system every single day. And so the system has kind of developed its own incentives to minimize the trials. And this is why we see, plea bargaining is kind of the predictable way that business is done. The prosecutor comes in, they charge the most harsh thing that they can possibly justify. They tack on every possible sentencing enhancement or aggregator or whatever, things that can potentially make the penalty worse. Tack all of those on, because then that gives them negotiating position to go to the defendant and be like, here, you can plead guilty to something a little bit less severe, and then we don't have to have a trial. And that's just kind of how the process works now. So that's absolutely going to be at play in this case, I would expect, because you have a death penalty on the table. And it's always possible that the state is going to be completely unwilling to take that off the table and bargain, right? They don't have an obligation to plea bargain. That's just how the system works for the vast majority, the bulk of the huge volume of cases that go through. But in any particular case, they don't have any duty to do that. And you have a high profile case, you got political implications, like you got reasons why maybe you wouldn't. But I generally expect, that it does, that type of thing does happen behind the scene, but there's a lot of different moving pieces with that. If you're real confident in your case, you're going to be able to convict him of the crime at trial. You just might not be able to get a jury to go with death. Then why not just give it a shot? What do you have to lose? You would get the penalty that you would likely be able to get through a plea. You'd be able to get that through the trial process anyway. So there's a lot of competing things going on with plea bargains, and whether we're going to see one, what type of form they take, and stuff like that. But yes, to answer your question, absolutely, people who are not guilty plead guilty. They do that because of the coercive pressure of the penalties that they're facing. They do that because of the calculated decision that you're at a systemic disadvantage as soon as you are accused of a crime, and you're sitting there in court at the defense table, and those prospective jurors walk into the courtroom and they see you sitting there and they think, I wonder what he did, just by virtue of the fact that you've been accused by the state. People assume there must be a reason for it. But it is typically, going to be built into the system. You'll see it when that happens, because people will enter Alford pleas. It happens quite routinely. Macfa in Sky. Law Mom, I assume courts are framing someone if things are sealed or not made public or streamed. Any Luigi updates as we wait? Love you. So I'm planning on doing a follow-up stream on Luigi's motion to suppress tomorrow morning. I've got it planned in my mind for 9 o'clock Pacific, 12 o'clock Eastern, but haven't totally nailed that down or set it up yet. But that's what I'm anticipating at this point. He's back in court today. They did not have court yesterday, but they did have court Monday and Tuesday. And so what I've been doing, since of course I can't be there now, is I'm trying to kind of compile what I'm finding from the different live tweeters, the different reporters that are in the courtroom that are telling us what happened. So I'm trying to reading through several of them and trying to kind of pick from all of them, because sometimes this one will report on something that other people didn't mention, or there might be minor differences between how it's presented. Sometimes, things will be unclear to one, but another will understand it a little better. So I've been going through and kind of compiling that the best I can to try to, just have as a clear a version as I can of what's happening to be able to go through and recap. And so that's what I plan to do. I've got the Monday and Tuesday days already kind of recapped. I'll go back and follow up this afternoon on what's happened in court today, and kind of see where things are going with that. So far, it just looks to me like there was some damage done by the defense that I haven't seen the state overcome yet. There's a lot going on from the legal perspective in terms of exactly what standard are we going to apply to the search. It's clearly going to be in the state's interest to apply the Pennsylvania law. He was arrested in Pennsylvania, searched in Pennsylvania, but it kind of looks like they were on the phone with New York the whole time. Their whole suspicion was generated because it related to the shooting in New York. They have, New York cops and prosecutors on the phone, like while they're in the process of figuring out what they're doing. So there's some pretty good arguments there that when you want to use this in a New York court for a New York prosecution, we're going to apply New York standards of search and seizure law. And those are far more protective of individual privacy and individual rights than the federal standard or the Pennsylvania standard. So haven't seen anything that's like, ooh, that blows up the defense argument on suppression. Where it stands right now, it looks to me like the judge has the facts to go either way. It's just which way does he want to go? He is certainly justified in finding that this does not qualify as a search incident to arrest under New York law because there was no exigency, certainly not after they had taken him out of the restaurant and they're still back in McDonald's with the backpack. It's not an exigent circumstance at that point. And then as far as the inventory goes, it doesn't look like they followed their inventory policy. If you're ostensibly doing this search so that you can document what these things are for purposes of liability protection, and they normally do that in the presence of the defendant, and it's not an evidentiary search, it's just record keeping. Well, then you need to act like that, and there are some pretty bad facts that suggest that isn't what was going on. They didn't do it in front of him. They weren't like even documenting really what they found at the time. They were going through and sorting out, ooh, this looks like evidence and this doesn't look like evidence. This looks like personal property. They're talking with the NYPD, the New York prosecutors and stuff while all this is going on. So if he wants to throw it out, I think he's got the facts to do it. It's just a question of where he wants to go with it. So yeah, keep your eyes open for tomorrow, and I'll get that stream set up, and we'll follow up on what's going on with Luigi this week. Lee Zecca, I'm worried about info defense hasn't subpoenaed. I want to make a PSA that wearing footy animal PJs under the age of 30 does not make one a furry. They're warm and cozy. I don't know if any of you guys are at all into like competitive running, triathlon, stuff like that. But there's like always people in the races that are like costumed, people like running costumes, and it's fun and stuff like that. It's just part of like having a good time and kind of keeping up morale, because like running 26 miles can really suck, so anything that like puts a smile on your face is good and encouraging. So you see stuff like that pretty frequently. And I've got an uncle who he was an elite athlete back in his day, and did all kinds of different competitions and stuff. But he still to this day does a lot of volunteering with like the local marathons, Ironman and stuff like that. Well, I bring this up because he's got a cow costume that he'll wear sometimes, and it looks like pajamas, like spotted pajamas, a little udder on it, and footies and a cow mask and stuff like that. He's not a furry. No, he's not a furry. Like not even close, not even in the same universe. Yeah, it's totally possible to wear like funny costumes and cute furry things. They're warm. Guys, have you ever been to Utah? Have you ever been to Utah? It's high altitude. It gets freaking cold. Okay, Utah gets freaking cold. It's like up on a big plateau. Some of these areas you're getting out into the mountains. In the north part of the state, you're up in the Wasatch, like up by Logan. You get past Provo down towards like St. George, where Tyler Robinson was, you're getting into like the north rim of the Grand Canyon is over there. You're in these areas where there's been a lot of tectonic uplift. You got these high plateaus. It gets freaking cold. So, if sometimes the fuzzy cow pajamas are like what's on sale, and so they're warm, and that's what you get. Like not everybody wearing an animal thing is a furry. So I second this motion. I'm totally fine with that one going through. Well, we're still waiting for court. I could talk a little bit, I guess, about I mentioned at the top I was on last night with Gary Melton over at Paramount Tactical on his channel. We were talking a lot about this case, just the evidence, taking questions about sort of where things stand, where things are going to go, and stuff like that. And one of the common questions that comes up a lot among just folks who have questions about the case and kind of what's viable and what's not viable and stuff like that. Just trying to get oriented to like, are there issues with this case or not? A big question comes up a lot about the text messages, because I know a lot of people read the text messages and they're like, these are weird. These are weird. These seem strange. And I'm not necessarily going to disagree with you on that. I'm not going to claim to be an expert on how Gen Zers talk to each other in text. I feel like kind of every generation has their own way of talking that sounds weird. And so I'm not prepared to say that certain aspects of what's going on in this text message chain isn't just young people kind of being young people and having their own little social quirks and things like that. But I don't know. I can certainly see a perspective of like, well, it's just sort of weird that you're like talking about what you did and all the details of why you did it and stuff like that. It just maybe seems a little convenient. And so there's been some speculation about like, well, could these texts have been planted? Could this be something that like the FBI made up or things like that? And I gotta tell you, my view on that is like almost certainly not. Okay. And it's not because law enforcement never makes up every evidence or plants things or fabricates things or things like that. It's that typically they do it in ways that are much more difficult to detect. The little drop the baggie of crack under the floorboard and in the car during the arrest. Unless you got everything on camera or you got, a third party, somebody witnessing it happening, it's really hard to prove that they did that just based on the fact that some crack is found in the car. So they know what they're able to get away with and what they aren't, because, the risks of getting caught are pretty significant. And so I think that these text messages being like fabricated or planted by the FBI or whatever, to me, this is just not remotely plausible as a theory, because it's going to be very easily detected by the defense. What we've seen of these messages so far, you got to bear in mind, this is not the evidence itself. This is a description of the evidence. This is a recounting of what the prosecution says the evidence is in their charging document. It's not comprehensive. I don't think it purports to be. Like, there's sections of it where there's ellipses, tends to show that there's parts of it that they're not including, for one reason or another, probably because they don't think it's relevant. Maybe the defense will disagree, but this is not intended or even purporting to be like an actual extraction of the text messages, or, you know, it's not like a screenshot of them or anything like that. It's just literally the prosecution has written down the substance of what they say the text messages are. But so there's going to be multiple levels of how the prosecution's account of these text messages can be corroborated or disproven by the defense very easily. And so these are supposedly obtained by, you know, Lance Twiggs showed him his phone. So absolutely, step number one, you're getting Lance Twiggs's phone and you're extracting it. You're extracting the data from it. You're using your Celebrite or your Axiom or just whatever forensic tool that you're going to use. Things are, you know, decades old now to be able to do this. It is going to get all of the data on your phone. And if these messages are on your phone, it's going to find them. So you're going to have them on Lance's phone. It's highly probable to me, just kind of, you know, having dealt with criminal investigations, I sort of know how cops like to do things. Very common in a situation like this, where like somebody has evidence on a phone or on a video camera or something like that, and they're showing it to you, and you want to have a record of it, but you haven't necessarily gotten the raw data file yet. They screen record it on their own phone. They take a video of what they're seeing on their own phone. I highly suspect that happened in this case because they're giving these messages purportedly verbatim. So they have some record of it. Or maybe they have, you know, Lance gave them screenshots of it or something like that. They have a representation of this conversation that they're relying on. And if that's not there, then the defense is going to be asking questions about, well, hey, how did you know what this was? How were you able to recount them so accurately? What was your basis for being able to do that? You're going to be able to go to Tyler Robinson's phone and extract his phone and find the communications on the other end of it. I don't know what service these guys use, but if these guys are on iPhones, you're going to be able to go and subpoena their iCloud from the server. And you're going to be able to see, oh, do they back up their text messages? If they back up their text messages to the iCloud, you're going to be able to get them from this third location, this server. You're going to be able to go to the phone provider. Say it's AT&T. You're going to go to AT&T and get their phone records, and their phone records are going to show text messages are being sent back and forth at these particular times. And you're going to be able to look and see, does that correspond with the conversation that the police are reporting took place? So there's a massive digital footprint that surrounds text messages that it's going to be detectable. It's going to be detectable very easily by the defense if you're just going to like kind of try to make something up and pretend and pretend that, you know, that it's evidence that you got from somebody's phone. Because they themselves, remember, the defense has investigative tools that we, the public, do not. They have subpoena power. They can depose people, get them under oath. They can go subpoena AT&T or whoever themselves, get those text messages. They don't have to rely on that from the FBI. They can get access to the phones themselves, do their own extractions, have their own experts involved. So it's so detectable, something like that. That's not where I'd be looking, you know, for law enforcement shenanigans in this particular case. If there's anything like that at all, it's going to be in places where it's harder to detect, or it would be harder to prove. And where that, you know, often comes up is like, oh, if there's interviews that are unrecorded, and then you just have a he said, she said about what the substance of it was. I just have to take the cop's word for it that somebody said something. Those are the types of areas where it's much more easy for law enforcement to manipulate it. So just in terms of kind of, you know, evaluating what is kind of a normal cause for concern in a case and what isn't. I gotta tell you, these this idea that the FBI planted the text messages, highly implausible, and it just suggests lack of familiarity with the types of resources that are out there to get this type of information. And that's not it's not like a diss on anybody or anything like that. Tyler Robinson himself was obviously completely unaware that he was leaving an entire digital footprint when he took his phone with him, to Provo, where there's going to be location data. Okay, that is one thing that we have not seen, because they do that after they identify him and get access to his phone. They already arrested him and had their probable cause before that. So we haven't seen it yet, but I guarantee you we're going to see this at the probable cause hearing. He thought, if we take his text messages at face value and that they are in fact his text messages, he was like, oh, as long as I can get the gun back, I haven't left any evidence. Dude, you will have left a massive digital footprint. And so if they have that, you're going to have a big problem. You're going to have a big problem. Because, I don't know, you're going to have to start to have a plausible explanation for why you drove 4 hours from St. George up to Provo, why you got up on the roof of this building at, 12:30 in the afternoon, right at the time when somebody is taking a shot at Charlie Kirk from approximately the angle from which somebody took a shot at Charlie Kirk. If all these circumstances start to add up, yeah, it's going to be hard to come up with an alternative explanation that still accounts for all of those facts that put you there at the scene with a gun, with your DNA on it, et cetera, et cetera. Shannon Brown, 614, with everything you've seen, presented, or heard on the side, do you think Tyler did this alone? I don't know. I still have questions about that. I think either way is feasible. There are certain things that I see in the evidence that make me question if he acted alone. One of those is that there was a phone call or some type of phone activity that they saw him doing at 11:53. It's mentioned in the probable cause affidavit. They're watching the security footage. They see some type of phone activity at 11:53, 40 minutes before the shooting takes place. I'm just interested in what that was. I'm not saying that is or isn't some kind of communication with a co-conspirator or accomplice or something like that. I don't know. I would want to know what that communication is, and they are going to find that out. They'll be able to see what that is. Again, either because they can get it from his phone or because they can get it from the server records or something like that, the service provider. I have some questions as well about the gun getting up to the rooftop. I recognize we've only seen a very limited selection of the evidence that the government has. They provided us with like screenshots from some of the surveillance video. But there does seem to me to be potentially a little bit of an inconsistency between the description of the gait of the person that they're watching on surveillance video, who they says appears to be having a hard time bending his right knee, and they think that that's consistent with possibly having the gun in his pants. Well, but then when we see these screenshots of Tyler on the stairs, we see one with his right knee bent, one with his left knee bent. We haven't seen the whole video, so I don't know if he is still, displaying this weird gait. It just, that on its face seems to be a little bit inconsistent with how they have described it in their affidavit when they're talking about the surveillance video. We know that the gun would have to be concealed. I mean, I think that's a fair assumption when we don't see it in these videos. But also, there's people around. You can see other people in the stairwell. there's witnesses. He's probably not walking up to the, walking up to the roof with a real visible gun or a real obvious problem that's not catching anybody's attention. But it just depends. So I do have some questions about that. He talks about having the drop zone for his gun. You know, he had to leave it at the drop zone, has to be able to get back to it. That to me is just a strange choice of words, because to me, when I think of a drop zone, it's a handoff. A drop zone is a point where you're handing something off. You're leaving supplies for somebody. You know, things are being parachuted in some, you know, to a drop zone, and then you know, and then they're being met up, or you know, somebody's like, you know, hiking out and leaving something in the drop zone for somebody else to pick up. It sounds like coordination, but this is not a sophisticated kid. You know, I don't know if he necessarily is using it in that sense or not. I'm not real sure why he would drop the gun anywhere at this point, but I could see a situation where, you know, he parked too far away, and now Charlie Kirk's been shot, and you know, everybody is looking around, and you're too concerned about like being spotted with this long thing in a towel on the way to your car, so you just ditch it in the bushes and call that a drop zone. I mean, to me, that's certainly possible. So I don't know. I think there are things that I see from it that make it, you know, plausible and kind of raise the question, because having an accomplice seems like potentially a plausible explanation of the discrepancies. But I don't know what else they have that might rule that out or rule it in. We do know that in one of the press conferences, Kash Patel was saying they're continuing to investigate the possibility of accomplices. Again, the digital footprint, they're going to have all that. They're going to have all that. They're going to know who he was talking to. They're going to have the accounts. They're going to be able to subpoena the IP. They're going to be able to go in and then identify the user, unmask the, you know, the username, find the person, have a little knock on their door. None of this is going to be hidden. So I don't know. I really don't. Brian Rambles, gotta tell you, you handled this well. Wow. Well, thank you. We continue to wait. I do appreciate that. You know, this is not my first rodeo with court, and court often is unpredictable. You gotta sometimes be prepared to kind of handle some things on the fly, but I'm really hoping they don't take too much longer, because I don't want to get to the point of just, you know, kind of rambling to fill space or anything like that. Ferry Naturate, hello. Rewatch crew, still at the beginning, but thank you for covering this and keep fighting for transparency. This cannot become the norm. It cannot. Okay, I saw something. I'm gonna share, and I gotta find it now. But over there on X, kind of horrifying, honestly. Yeah, I'm gonna have to sort through a lot of stuff to see where it is. There was a judge over in New Hampshire that ordered a reporter, a news reporter, that he was basically not allowed to report on information about a court case that he came across. Here it is. Let me go ahead and share this with you guys. How's that? How's that look? This one right here, I'll make it bigger. Steve Porter. He couldn't report on this case because the judge threatened to hold him in contempt if he did so. So he just has this story about, you know, this case involving a bunch of health clinics in New Hampshire going into receivership. So they've got financial problems, and there's, you know, some issues that are going to be related to that, because if you just like stop stop randomly applying health, providing health care to people, that can have some pretty serious consequences. So he gets this information about this case, but then the judge tells him, you're going to be in contempt if you report about it. So they learned about this back in November, 2 weeks ago. And this is the first time they're being able to report about it because the judge issued this gag order. Let's see if I can bring this down a little bit and bring us over here. This is a gag order that a New Hampshire judge signed sua sponte. Okay, sua sponte meaning nobody asked him to do this. He did this of his own accord. He had sealed the court. He had sealed the case on November the 25th. But by inadvertence, certain portions were accessible to the public online. So they screwed up. The court screwed up. And because of that, a diligent reporter from the Boston Globe was able to access some of the case information and documents. Yeah, this is what's going to happen if you don't do what you say you're going to do and seal the stuff. People are going to find it. This, is not unheard of. This is a thing that happens. This was not supposed to occur. The plaintiff submitted compelling reasons for the case to be sealed at this point. The reasons for the seal would be thwarted if the case information is disseminated. I don't know what that possibly is, but there is such a strong presumption against doing court in private that I got some serious questions about sealing an entire case. Access to judicial records is part and parcel with the First Amendment right to know what the court is doing. The Supreme Court has not specifically applied that to civil cases, but multiple districts have, multiple federal circuit courts of appeal have addressed that. As far as I know, everyone that has looked at it has extended it to civil cases because the same reasoning applies. You get to know if people are getting special justice in the court, if the processes are being corrupt, if things aren't being done the way that they're supposed to, we get to know that. So I don't know a possible reason this is that is going to overcome that presumption. Therefore, Stephen Porter, the Boston Globe, and any other person that has access to the information obtained from the sealed court file is immediately enjoined from disclosing or distributing the information documents. Any such disclosure in violation of this order may be subject to a finding for contempt of court. And so now it's time for this judge to go back to law school, if he ever went, and read the Globe newspapers case, because Globe newspapers was one of the very early U.S. Supreme Court cases on gag orders in court. And it's quite clear. You cannot gag the press. The press has a First Amendment right to report on the information that they obtain. And if they obtain this through independent investigation, such as by finding it on your website where you didn't mean to put it up, but you did, they get to report on it. You don't get to gag the press. So this has been like black letter law for not quite a century, but well over 50 years at this point. Black letter law. You do not get to impose this kind of restraint on the press because you are not a freaking monarch who rules over us and decides whether or not we get to see what you're doing. You are accountable to we the people. Now, apparently in New Hampshire, they aren't all that accountable to we the people because they're appointed judges and they get a lifetime appointment. They can only be removed by impeachment. And so, I'll give you several guesses on whether somebody who has the kinds of political connections that will get them a judicial appointment in the first place is likely to suffer political consequences when they completely abdicate their responsibility to uphold the Constitution of the United States of America. To be clear, it does not appear that he knowingly violated the order sealing the case. Nevertheless, the case is sealed and disclosure of the information or any documents obtained is strictly and unequivocally prohibited pending further order of the court. This order is effective immediately and itself is sealed. We also are not supposed to get to know that this judge is spitting on the First Amendment. We don't get to know that either. Talk about lack of accountability. This is wild. It is to be said only to Mr. Porter, the Boston Globe, and the plaintiff. Maybe they can get that right, this time. Maybe they can get that right. So yeah, that was a pretty wild thing to see. So apparently, Mr. Porter was able to get a lawyer involved. They were able to get that. Order vacated. But this stuff, like, it's, again, I just don't know if this is new or if we're just seeing it more, or if like judicial quality is going down. And so the judges are getting dumber and they don't know. Dude, you are so not allowed to do that. Like, this is not even a close question. But it just increasingly comes up. It's mind-blowing. So yeah, it's cause for concern, in my view, when the government doesn't think we should be able to inspect what it's doing, because that is the kind of arrogance that you expect from a tyrant. That is not the kind of openness and respect that you expect from a democratic institution. So appreciate your comment very much. Black Swan Revelations, first time watcher of your channel. Well, thank you so much for being here. I sure do appreciate it. I will love it when we have something more substantive here to watch together and talk about. But it's a lot going on with this case, and it's still so early. That's the thing that I keep coming back to. There's this I don't even know what it is. I don't know if it's like an entitlement that we're so accustomed to the information on demand that we expect to have all of our questions answered right now, and we expect for all of the information to be made available so that we can pick through it without regard for how that plays into the court process and the rights of everybody involved and so forth. I don't know if like it's that, or if we just kind of have a lot of people that are interested in this case because, variety of reasons, who it involves, political implications and stuff like that, but maybe aren't real familiar with the criminal process generally. I don't know what the reason is, but there is just such a remarkable lack of patience to wait for things to play out the way that the due process that our Constitution calls for has established. I'm not really sure what to make of that. I really don't. To me, I've been in the system for almost 20 years, seen this happen, thousands of cases. I've walked through the system, seen the investigation, seen how they're handled and so forth. And there's really nothing remarkable about this at all so far. There's really not. The probable cause itself, the evidence that they claim they have, nothing really remarkable about it. It's the kinds of things that I normally expect law enforcement to have and do and rely on. The conclusions that they've reached based on what they've gathered seem to me to be pretty ordinary types of reasons and stuff like that. And I mean, I'm like the last person who would be like, "Ooh, trust the government." Trust the government. Everything will be fine. I mean, hello, it's like the first thing we we tell people, oh, the government wants to talk to you. You better shut up. You better not have anything to say. The government is not your friend. You can't trust the government. But to take that to a level of like certainty that there's something wrong here, I'm not understanding. I'm really not understanding why that is. I'm seeing a lot of like really strong opinions about the investigation when we know next to nothing about the investigation at this point. The investigation at the time of the probable cause affidavit was just the beginning. This is the bare minimum of what they needed to get started, because now that they know that it's Tyler Robinson that they're accusing, that they think committed it, now they go through a massive process of investigating Tyler Robinson. Again, looking at his digital footprint, looking at his activity, looking at where he's been, looking at the things that he's said, looking at people that he's talked to. But we're not going to see that. Why on earth would it be expected that we would see that? We'll see that in court. We'll see that in court. I don't know. Brian, Merry Christmas. Thanks for all you do. Well, thank you. And Merry Christmas to you too. God, it is coming right up, isn't it? Holy cow. 2 weeks. 2 weeks. I got 2 weeks to get ready. I'm not doing like the big Christmas decorations and stuff like that this year. I can barely keep my house cat proof as it is at the moment. I shudder to think of what would happen with tinsel and, lights and baubles and things like that around. So, what else do we have here? I am thinking the only other thing that we haven't really talked about so far that is on our docket for today is this motion for intervention. So we could go ahead and pull that up and take a look at it. Show you guys what's going on with that. We've got their motion, and then we've got the defense's response to it, which, like I said, I found this a very interesting sort of choice of priorities thing to be spending your time on. Just seems, again, I don't have the inside view behind the scene. I don't know what's going on in this particular case. I just kind of know how I expect things to go in a case, in a normal case. And at this stage of the process, this is one of the busiest times to be the defense lawyer, because you are trying to get up to speed on the prosecution's case as fast as you possibly can. You are doing everything you need to do to test it. You need to get your own experts in a row. You need to be following up with witnesses and verifying things with them, doing follow-up with them. You need to be interviewing your client and finding out from your client, what's your version of this? Are there other places we might be looking for information, for corroboration? You're investigating mitigation. You're looking into his background as much as you possibly can. You're looking into his psychology and his thought process. There's so much to do because they need to have a lot of that done before the preliminary hearing. And so, to choose how to spend your time in this phase of the case, it speaks somewhat to me to the priorities. And so to have made it a priority to just focus on an issue like this that seems to me to be like super technical at best. It's just, I'm not sure that I understand the process unless, you already know you don't necessarily have a lot to work with on the evidence side. So this is the motion. You guys see that? Let me check and see. Yeah, that's nice and big. So this is the motion. Salt Lake Tribune, St. George News, AP, Fox 13, all these different media organizations. That's what I mean when I call it a consortium. They hired their attorney, and they respectfully filed this motion for limited intervention and request for notice of motions to close, seal, or reclassify in the above captioned matter. Courts already recognized media interest is unprecedented. It has recognized the public's interest in and newsworthiness of these proceedings, which it did. That's a quote directly from one of the court orders. And so to safeguard the rights of the press, the public is asking, the media interveners are asking to grant the motion for limited intervention, direct that all motions or other requests that would limit access to records or proceedings in this matter be promptly served on media interveners, and that media interveners be allowed to respond and otherwise be heard on access matters before any order limiting access in this matter is entered. So it's a pretty limited request. They want to be able to be notified and have standing to participate anytime there's going to be an issue that comes up that involves the public's right to know what's going on. The media doesn't have special rights vis-a-vis, reporting or access or anything like that. They don't have any greater right to information than any member of the public does. But they are still kind of generally recognized as the transmitters of information. Their profession is to be the ones who are able to go and gather the information and report it to us so that we all know what's going on. So kind of common for the media to represent the public interest in information as a whole, because, hey, they've got an interest in having the information so that they can report it and make money based off of that. So the relevant facts here, they're media entities engaged in the business of gathering and disseminating news, local and national organizations. They all share an interest in ensuring access to this criminal proceeding and contesting closures or restrictive classifications, including closures and classifications that have already taken place or been requested. In the 6 weeks that this matter has been pending, the court has carefully protected press and public access rights. I tend to agree with that. Notwithstanding that we're sitting here waiting for court to come back because they close the door to us, we don't get to see. And it's not the first time we're having this hearing at all because of the last time when they closed the door that we didn't get to see. Nevertheless, by and large, the court has been pretty respectful of the public's right to know what's going on. As the court has recognized, this is a serious case that has garnered national attention. From the start, that attention has included media requests for access to these proceedings. This court has routinely and appropriately granted those requests, imposing conditions as needed to account for other competing interests. They have routinely granted the request to televise, and part of that is a product of the way that the rules are written in Idaho and in Utah. Utah has decided, kind of unusually, I guess, from my perspective anyway, that they're very much in favor of cameras in the courtroom. And so if there is a request for somebody to televise a court proceeding under the Idaho rules, it presumptively should be granted unless there's a real good reason why you shouldn't. And the judge has to justify that, has to articulate that in their order denying that access. Not a real common view about transparency in this day and age. We still have the federal courts completely, well, I can't say completely closed off to cameras because they do have a extremely limited pilot program where they are allowing cameras in some courtrooms, but it is certainly not extensive. You have most jurisdictions where it's just discretionary. The judge can do it or not as they decide, and they frequently decide not to, but sometimes they do. So just this very strong presumption in favor of having the cameras there is a little bit unusual. Unsurprisingly, both parties have attempted to chip away at these access rights almost immediately. On October 9, 2025, defendant filed a motion to appear in civilian clothes and without restraints. When it came time for the state to respond, it moved to classify its response as private. In justifying that classification, the state stated that the response includes information from the court's security director regarding specific security measures in this case. Even if this were true, and the press and public cannot, of course, verify the contents of a private filing, including whether these security measures could have been protected through redaction rather than a private classification, the state appears to have used that private filing to argue for limiting press and public access to these proceedings. In Section 5 of his reply, defendant stated that he agrees with the Utah County Sheriff that the court should limit media coverage or video or photographic coverage at the least, so defendant's physical appearance is no longer the subject of interest. I don't think that's quite how it works. I don't think that by cutting off the supply, you automatically cut off the demand. Otherwise, we wouldn't have a drug problem in the country anymore. But, you know, perhaps their point is, well, that it's not being fed. The appetite is not being fed. Based on that reply, media interveners understand that in addition to relaying details about security measures in its opposition to the civilian closed motion, the state also made broad arguments about limiting media coverage in this case altogether. Media interveners, of course, oppose those arguments on their merits. Just as critically, however, media interveners object to the practice of placing arguments about restricting public access to these proceedings in a non-public filing. That seems legit to me. That seems pretty legit to me, that you should not be litigating whether the public doesn't get to see anything away from the public. You should not be able to hide all of that. This is another area where there's a fair amount of case law on this. Again, this is not the first case ever that's gotten public attention, that's had things come up that, you know, like, ooh, if it gets out, it's going to make the defendant look really bad. And so we have to, we have to come up with some kind of accommodation. This is far from the first time this has come up. It's been litigated over and over and over again for decades. And one of the real common themes that comes up when the court wants to close a hearing, close the courtroom to the public is entitled to an opportunity to be heard on that. You don't get to just do it and spring it on the public. Now, I'm not saying that doesn't mean they don't do that anyway. We're legal realists here. We understand that what courts do doesn't always correspond with what the law says they're supposed to do. But if they're following the rules that we're all expected to follow, you got to give the public a right to be heard. And so it's going to be pretty hard to do that if you're concealing the fact that you're even having the conversation at all. Fortunately, the court again protected the press and public's access rights. In granting in part and denying in part defendants' civilian close motion, the court declined the invitation to enter orders limiting media coverage of this proceeding. Instead, the court made a set of practical amendments to the decorum order, including targeted restrictions regarding when defendant can be recorded or photographed. Can't show him coming in and out of the courtroom, can't show the shackles. In doing so, the court reiterated its commitment to open and fair proceedings, recognized the public's interest in and the newsworthiness of these proceedings, identified a benefit in allowing the public to observe the proceeding through electronic media coverage, and sought to promote a healthy balance between preserving the defendant's constitutional rights and the media and the public's interests in viewing the proceedings. The court should not be forced to police these critical interests alone. We were so, before that last hearing, when he announced his ruling, we knew, we're dependent on the court to be protecting the access right here, the public's interest in transparency, because media hadn't appeared at that point. None of us had an opportunity to speak up. So we knew we were dependent on the court. But the court should not be forced to police these critical interests alone. And in fact, as detailed below, the media hold a constitutional right to intervene in proceedings like this one in a limited capacity to oppose attempts to restrict public and press access. So the rest of this is their legal argument. They go through a lot of case law from all under the country. A lot of these are very famous, well-known cases, the press enterprise cases. There's Press Enterprise 1 and Press Enterprise 2, Waller versus Georgia, very, very famous one. Here's the Globe newspaper case. That's the one I'm talking about. That judge in New Hampshire. Dude, have you ever read Globe Enterprise? I can get you the full citation here, right here, 1982. 1982. So not quite 50 years that's been the law, but been out there for quite some time. And so, all of these are just basically establishing, restating, not just that the public has a right of access, but why. Why do we do that? Because if you don't let the public in, it creates an impression that you're being secret. And if it's secret, then we don't trust that it's fair. And so even if it is, people lose faith in the institution. People don't necessarily trust the outcome, because you gotta kind of treat people like they have their own minds. They can think for themselves and make up their own decisions. And so just because somebody says something is fair doesn't mean I'm going to agree with them. If we are a society of, equal democratic participants, then each of us get to form an opinion about that for ourselves, and we get to advocate for that, and we get to elect representatives who will, see things the way that we do. But we don't have to just take their word for it. It's not the way government works here. And they make some comments here about the conflict between, information, a lot of information. Yeah, sometimes that can be prejudicial to the defendant. So there's a landmark case that is brought up in this brief. The defense brings it up all the time in theirs. But a Shepard versus Maxwell. And this case basically stands for the proposition that media interest cannot be allowed to turn the court proceeding into a complete circus. And so they describe things going on in Shepard v. Maxwell. This was a case that was like 100 years old or something like that. It's an old one, maybe not that old, but it was a long time ago. And they're talking about things like, the press is running in and out of the courtroom. They're grabbing the witnesses for like interviews in the halls. They're, peeking into the files while the people are coming in and out of court. They're, just like super over the top stuff, right? It's like probably the most extreme kind of situation that you can imagine. And so it's a case where the U.S. Supreme Court said, look, this was so bad that it rose to the level of a due process violation. There was no way this guy was ever going to get a fair shake. The whole process itself was tainted by what the court allowed. And so the court has some responsibility to maintain some kind of control over the proceeding to prevent things like that from happening. So that's kind of one of the early cases that establishes like one end of the spectrum when it comes to the court's power to intervene with what the press is doing, maintain its own courtroom, its own decorum, and stuff like that, in order to safeguard the defendant's right to a fair trial. However, just because the public is interested in a case and there's media about it doesn't mean he's not going to get a fair trial. They're not like mutually exclusive things. Most of the time, publicity about cases and getting a fair trial can coexist. And again, it's because we have a lot of these protections in place, like jury selection being the big one. So you got tension here. You got tension, like recognition that, yeah, sometimes things can reach the point of impairing the fair trial, but the public's got to have some kind of confidence in what is going on in there. And if they can't see it, they're much, much less likely to have it. So because of the fact that those conflicts sometimes have to be navigated and negotiated and litigated and so forth, courts have allowed the press to intervene in these types of disputes for a long time. So they've got cases here from federal court. They've got some cases here, from state court that involve situations where, the press has been allowed to participate, to advocate for the right of access. They've got this kind of multi-factor test that gets applied to determine. And so at the end of the day, there's no question the media has the right to participate. The question is really only, what does that mean? How does that look? What does that look like? What does that look like for practical purposes? And so they're arguing you should implement that right. You should recognize that right by allowing us this intervener status, meaning we are parties, but just for a limited purpose. So they say the rules of judicial administration kind of give some guidelines on that, because it sets up this process that we're following with respect to this particular hearing, where the court can request notice. They have a hearing. We have an opportunity to be heard. Here's the rule I was looking for. This is not actually, I guess, the rule. This is from the case. When I was looking up, like, why do we have this hearing closed? Isn't it weird to be having a closed hearing about whether the hearing should be closed? A closure order must be preceded by notice and hearing. Representative members of the media must receive notice of the motion for closure, and along with other interested parties who seek to participate, must be afforded an opportunity to participate in the proceedings upon the motion and to the maximum extent possible. What about everybody else that's sitting in that courtroom? They have the same standing, same right as the media to participate in a question involving public access. They're a member of the public. Didn't ask any of them if they want to say something. We didn't know this hearing was going to be closed. So, somebody who was interested might have otherwise shown up, wanted to speak. I don't know. Anyway, this seems a little bit inconsistent with maybe that process and that philosophy anyway. So they've directed that closure hearings should be open to the greatest extent possible. Should be open to the greatest extent possible. I'm just going to again suggest we should be able to be watching this hearing. And if somebody needs to say something that they think we shouldn't hear, they can just go up to sidebar and say it. This wholesale closure about closure, it's not a good look. It doesn't seem to me to be consistent with what the requirements are, or what the principles are that give rise to these rules in the first place. And wherever possible, exclusions from closure hearings should be narrowly tailored. Transcripts should be made available, and any closure order should be accompanied by suitable written findings. We don't have any of those things yet. So by seeking limited intervention and in order setting proceedings for closure challenges, the media interveners are seeking relief for an infringement that has already occurred, an attempt by the parties to not only seek closure of these proceedings or other access restrictions without required notice to the press and the public, but to do so in a non-public filing, right? The whole sealed response by the state, where apparently they said, hey, the way you can deal with the prejudice of Tyler Robinson being shackled and in jail attire is just pull the cameras out of the courtroom. Maybe just close the courthouse door altogether. We don't know, because it's sealed. We don't know what they advocated for. But that's what they're talking about there. 2 days ago, the parties doubled down on efforts to shield those discussions from the public eye by asking that the transcript of the October 24th, 2025 hearing be designated as private, ignoring narrower means of protecting security or fair trial interests, including Taylor redaction. And they did. They just flat out designated it as private, the whole thing in the first instance. And it's only after the media has gotten involved that they've been like, okay, well, maybe we can just redact these parts. It's just, I recognize that each of these parties kind of have their own interests and their own responsibilities. And this is just one of the limitations of the judicial process, is that neither of them particularly have an interest in us and our rights. Tyler Robinson's attorneys, their job is to try to do what is in his best interests. Okay, they're coming back into court finally. Let me get us over there. They're back. So, their interest is in protecting his rights. The state's interest is in, ensuring that, they want to convict him. Obviously, they believe they are representing the interests of the public by doing that. But they also, want the process clean. They don't want there to be appellate issues. They don't want this to come back and them have to do it all over again. But their primary interest is in this proceeding. So, we shouldn't have to require the media to show up and say, once again, these are the rules that you need to follow. Like, it would be really nice if that would have just been respected in the first instance, but it's just part of the nature of, the process and the fact that it is adversarial, that our interests are not theirs. And so they aren't necessarily going to protect our interests if it's not in alignment with theirs, and if they think they can get away with it. And at that point in time, there's no media intervention, no reason to think that they were going to be called on to be a little bit more considerate, a little bit more careful, a little bit more targeted with what you're trying to keep us all from seeing. Thank heavens, court's about to come back, because I think I might lose my voice pretty quick here. There's no sound, but it's not me. It's not our end.
We're going back on the record in case 251-403-576, State of Utah versus Tyler James Robinson. I note the presence of counsel that previously entered their appearances. We have come out of the closed session and concluded that business. However, the court became aware of an event that happened before.
Oh boy.
And my understanding was during the open portion of this hearing earlier that there was a violation of the standing decorum order as it relates to transmission of these proceedings. I want to hear from counsel, and,
Oh boy.
and then I will make a ruling concerning that shortly thereafter. Ms. Visser.
Thank you, Your Honor. I'm referring specifically to Rule of Judicial Administration 4-401.01. This gives the court discretion to terminate or suspend electronic media coverage at any time without prior notice, if the judge makes particular findings and that the specific circumstances warrant it. It is our position, the defense position, that there has been a violation of the decorum order. It is our understanding that those live streaming this signed and declared that they would follow the decorum order and they violated it. So we are requesting a sanction. We believe these court's orders are binding and they need to be respected. We also believe that it threatens my client's right to a fair trial. It's the whole reason we filed a motion in the first place to remove his shackles. It's our understanding that his shackles are visible. It is also our understanding that potentially some audio from counsel table was heard. We are definitely taking more measures on our own to ensure that that does not happen again. But there has also been some filming of computers and materials at counsel's desk. That's entirely inappropriate. And I think everybody in this room will agree that's entirely inappropriate. So we are asking for some remedial measures here. We're asking for it to terminate for today, and we can proceed after that.
Thank you, Ms. Visser. To the state.
Your Honor, the state, as stated earlier, we believe that the court's order was very clear. And if there's been a violation of that order, then we agree that there needs to be some measure taken. We'll leave it to the court to decide the appropriate response to that violation. But we agree that any violation of the court's order needs to be addressed.
Thank you, Mr. Ballard. To the press, attorneys for the press.
Your
I think
Honor,
we need
Jeff
some
Hunt,
evidence.
Media interveners. This is the first time that we've heard about the violation. We've not had an opportunity to look at the video or investigate the audio or look at the capture of the computers. But filming of the inadvertent filming of the shackles, I did talk to the pool photographer. My understanding is that there was a zoom out shot that did inadvertently show the shackles. That was improper. That was inadvertent. And we apologize for that. They've taken measures to make sure that the pool video that is disseminated to the rest of the pool does not contain any capture of the defendant in the shackles. We can't do anything about the live stream, of course, but we can control what the rest of the video is that we capture and disseminate. So that is being done. The audio for counsel, my understanding is the only audio that they picked up was from counsel's microphones. I don't have any further information about that and whether that's a violation. Filming of the computers is not a violation of the decorum order. If the capture can show the document that counsel is looking at, then that is a potential violation. So I just don't know how much detail the shot is that is of concern to the court. But I'll just say that we reiterated as soon as I heard this from Mr. Ballard with the pool representatives that this is very important to follow to the letter the court's EMC order. They understand their obligations. They take that very seriously. They're not perfect. Mistakes happen. We're trying to correct as much as we can on that. But we think termination is not an appropriate remedy. An admonishment from this court, a reminder that they need to follow to the letter the court's EMC order is appropriate. That's the message that counsel has delivered to the media representatives and the pool operatives. And we think that is the appropriate remedy.
Thank you. Thank you.
I just want to make it clear, we're still receiving messages that shackles can be seen on the live stream as we restart it. So it's still a problem.
Thank you. I appreciate all parties weighing in on this important matter. And I find that there was a violation of the standing decorum order that was in effect as of October 30th, 2025, based off what's been proffered, as well as the EMC order signed by the court. As previously stated by Ms. Visser, the court does have discretion in determining whether to terminate the broadcast of these proceedings. And again, if there's specific circumstances warrant such action, that the court would need to make findings in order to do so. I find that excluding the cameras from the courtroom would be disproportionate for this hearing. I find that given making it very clear first that the transmission cannot begin until court is in session and must end as the court ends the session, and cannot be filmed before or after. The filming of, as previously stated in the decorum order and EMC, must be followed to the letter. The sanction for today is that this camera will be relocated away from defense table to where the bailiff is, where Jeff is standing over here. I want to immediately address any possible transmission of shackles, as previously stated by counsel, and remove the possibility of capture of screens of the computers at defense counsel's table as well. In addition, if there's further violations of the standing decorum order, this court does have the right and will exercise termination of broadcast of these proceedings. And I simply want to put all parties on notice, to the press, to all parties, that this court takes this very seriously. While the court believes in openness and transparency, it needs to be balanced with the constitutional rights of all parties in this case. As such, we will take a brief recess to allow the relocation of the camera and to the place
Another
indicated
recess
by the bailiff, and then we will resume these court proceedings. I am anticipating this take perhaps 5 minutes. All right, and then we'll come back on the record and handle the remaining of this hearing. I appreciate the patience of parties as we move forward. We are trying to do the best.
So they cut it off again already. Oh, well, you know, seen this story before, haven't we? We were just talking about how over in Coburger, media just couldn't follow the rules. They're crystal clear. Just couldn't do it. Went and got the cameras yoinked for all of us. Fortunately, they had the backup that they let us watch in that particular case. But I don't blame, I really don't. I don't blame the defense for being annoyed and frustrated with that. I don't blame the court for, it's just so disrespectful of the process, of the institution. Consider hitting him in the pocket, you know. That's where sanctions hurt, right? Hit him with a fine, possibly. But I appreciate this judge. I don't know about you guys, but whenever he talks, I'm like, we're getting to know him. It's still really early in this process, so we're kind of still getting to know who he is and how he thinks and stuff like that. But is it just me, or do you find him incredibly soothing? I just find him very soothing. He seems so even-tempered, so not excitable, so just direct and to the point. I'm like afraid if he ever gets mad, it's gonna be like really scary, because it will be so out of the norm of how I'm kind of normally starting to expect him to behave. Yeah, this was a close call. He absolutely would have had the right to say, you were warned, you couldn't do it, get out, we're done. There's no constitutional right to have the cameras in the courtroom. He could have done that. And so I so appreciate his recognition. That would be disproportionate, because that's going to punish all of us who are interested in the case and who are not misbehaving for, you know, the lack of discipline of one camera person who just seemingly can't be bothered to familiarize themselves with the details of how this is supposed to go. I got to tell you, though, this doesn't give me a lot of hope for future proceedings. He's made it clear. This is a warning. You guys get your warning. Okay, you guys get your warning. But there's a very implicit, if you do it again, things might get worse. And you kind of got to back that up if you're a judge. If you threaten things you don't intend to carry out, you lose authority real quickly. And the problem is that it's routinely not the same camera person. Okay, whoever this was who made the mistake today may very well not be the person who's in court the next time. And then the next person comes in just as ignorant as this one was. Doesn't familiarize themselves. Nobody bothers to fill them in on what the restrictions are, or thinks, hey, better make sure he complies to the letter with what he's supposed to do and not do. So I don't know, guys. I don't have a ton of confidence at this point that the media is not going to blow it and lose us our live stream. And if that does happen, I just very much hope that we have the same kind of backup situation like we had in Kohberger, which they should. We already know they do video court through their own system. Maybe we can just watch it through that system, Judge. Go ahead and boot the court TV cameras out, or whoever it is that's running it. I don't know who's running the pool camera. I don't have confidence that they're not going to blow it. I really don't. I, for one, I didn't hear counsel audio. I didn't hear anything from counsel table. I was talking about, lip reading because you can see him talking. But I couldn't see, couldn't hear. I couldn't hear. Maybe other people had it like turned way up and could hear. I also didn't see the computer screen. In fact, I kind of looked at the computer because I could see the angle that they were at the defense table. And you could see the side of the computer. I didn't see a point where you could see the computer screen, although maybe there was at some point, but definitely didn't see anything on it. And I also didn't see his shackles. I mean, they're telling me they were visible. Okay, I didn't see them. Felt like we were kind of looking for him too. We saw his hands were free. Commented about that. But just because I didn't see it doesn't mean it didn't happen by any stretch of the imagination. And so if it's out there to be seen, undoubtedly people saw it. But that said, I do think, like he said, it would kind of be disproportionate in light of what actually happened, because like, seriously, if it's a blink or you miss it kind of thing, how prejudicial is that to the jury? I don't know. I really don't know that that's a huge problem at this point. The thing about the shackling
and responses, but I'll hear
here they
a brief
go.
argument and then we can go from there. Mr. Ballard.
Thank you, Your Honor. With respect to this motion, I think as we've expressed in the past, everyone in this room shares the same goal, and that is to ensure that there's a fair trial that happens in this case. And we recognize that the court's pretrial publicity order is intended to further that goal. And again, as I've stated before, the state plans to try this case once.
Mm-hmm.
The state is also committed to complying with its ethical duties with respect to pretrial publicity. We have complied with those duties. We will continue to comply with those duties. The issue we bring before the court here is that there's one portion of the pretrial publicity order that can be interpreted to reach beyond those ethical requirements and have the effect of being what would be an unlawful order, an unlawful prior restraint on speech. And our goal, therefore, is to get an order that's clear, that's lawful, and that the state has the ability to comply with. And the issue with the order that the state has is the use of the term witnesses in the order.
Mm-hmm.
We believe that term's vague and ambiguous. Does it mean anyone with relevant information about this case? Does it just mean those people that are going to be subpoenaed to testify in this case? Or is it limited to just the prosecution team? And I think as we've expressed in our filings, we believe that the court intended that that term just be limited to the prosecution team, because that is the way that Rule 3.8 reads. Rule 3.8 of the Rules of Professional Conduct that deals specifically with requirements for prosecutors talks about investigators, law
Nope, it's
enforcement
papers.
personnel, employees,
Get that
or
freaking
other
camera
persons
back.
assisting or associated with the prosecutor. So in other words, the prosecution team. And there's no rule or case law or statute that expands the prosecution's duties beyond that group, the prosecution team. So with respect to clarity, we're seeking clarity as to what exactly does the court mean by witnesses. And we think the court just means the prosecution team, because if that term stretches beyond just the prosecution team, then the order as written, we don't believe is a valid and lawful order, because it would result in a prior restraint on certain speech, and at the very least would have a chilling effect on that speech. If the prosecution agrees that we have an ethical duty to take reasonable measures to make sure that those who are identified with the prosecution team are alerted to the requirements of the court's order, and to make sure that they do not make a statement that the prosecutors themselves would not be able to make, a public statement. But if the order extends beyond that, then we have concerns, because a prior restraint is an order that forbids certain communications in advance of the time that they are to occur. And as the Court of Appeals has recognized, the Utah Court of Appeals has recognized in State versus LM. And widespread publicity in a case does not itself justify a prior restraint.
Correct.
As the United States Supreme Court has recognized in Nebraska Press Association, there's no justification for a prior restraint unless it's clear that the further publicity, unchecked, would so distort the views of potential jurors that you couldn't find 12 jurors who could be fair and impartial. That's the high standard that applies in this case. And so in order to apply a prior restraint to persons beyond the prosecution team, the court would need to engage in a very detailed and demanding analysis. The court would have to make a factual finding of necessity, that the speech that would be restrained poses a risk of material prejudice to the ongoing judicial proceedings. The court would need to make findings that there are no less restrictive measures, and that the prohibitions are likely to prevent the potential prejudice, and that whatever prohibitions this court decides on are very narrowly tailored. And as the state has explained, the Spencer versus State case from the Arkansas Supreme Court that just issued earlier this year is very helpful, I think, on this issue in explaining the analysis that applies to various different people that might be associated with the criminal case. You have attorneys, that category of trial participants. Certainly the court has the highest degree of ability to be able to restrain the speech of attorneys. And in fact, as I've expressed, the ethical rules require that. But when it comes to trial participants, like witnesses, the standards are more demanding as far as restricting the speech of trial participants. And as the Spencer case pointed out, non-attorney trial participants, the court can impose a restraint on their speech only to the extent that the court first finds that any speech by those non-attorney trial participants poses a serious and imminent threat of material prejudice to the ongoing proceeding. And I think the court also needs to note that there are several people associated with this case who have very significant interests in exercising their First Amendment rights in
Mhm.
talking about how this case has affected them.
Mhm.
And of
We're talking about
course,
Erika.
can't say that one person's First Amendment right is more important than another person's, but there are certainly some people here who have a larger, some people involved who have a larger or
Platform.
greater interest in speaking than others. And so I think the court needs to take that into consideration if this order is meant to apply beyond just the prosecution team. And then finally, as far as making the order, so we need a clear order, we need a lawful order, and then we need an order that the state can actually comply with. And the state recognizes that there are serious sanctions that this court can impose for violations of a court order, as we've just seen. And so we want to avoid these. We want to avoid litigation over whether there's been a violation of the order. And as it stands right now, we don't believe that there will be any issues if the court limits the term witnesses to just the prosecution team. We can comply with that order. It gets more difficult for the state if the term witnesses then applies even broader at this stage of the litigation for the state to be able to comply with that order, depending on how the court clarifies what witnesses mean. Does the court have any questions for the state?
No, thank you,
Okay, thank
Mr.
you.
Ballard. Mr. Novak.
Thank you, Your Honor. I'm going to try to be brief because our views on the propriety of the court's order were set forth in a publicly filed document, which, of course, the court has reviewed. And the first thing that I want to say is that the order that the court issued is not a prior restraint on any member of the public. And it's certainly not, I think as the state's motion suggested, some sort of a prior restraint on the press. This has nothing to do with the press. The order, as we noted in our papers, is directed at the conduct of and the court's expectations for counsel. So even if under that order that the court issued, somebody who we could all agree is a witness within the court's definition of that, made public statements which implicated Mr. Robinson's fair trial rights, the potential sanction is on the party who had a duty to make a reasonable effort to notify witnesses that they should not be doing so. If I represented a witness who was accused of saying too much publicly, the first thing that I would tell this court is the order isn't directed at the witness. The order is directed at the counsel for the parties. There may in the future be some theoretical situation where the court issues orders that control the statements or conduct of specific people, but this, or other than counsel, but this order is directed at counsel. And we have no, meaning Mr. Robinson's defense counsel, have no problem complying with the order. And we also think that we understand what a witness is when the court uses that term. So it is our view that the court's order is not overbroad, it's not vague, doesn't put the state or the state's attorneys in some untenable position. And I think it's a little too simple to say witnesses are either everybody under the sun or people who are under subpoena at the last second, because counsel have not only the training, but a duty to figure out along the way who the potential witnesses are and to notify those people. And yes, down the road, maybe there's going to be an issue, and maybe an attorney on either side of litigation is going to have to explain to the court when a particular person did or did not become a potential witness in the eyes of that party.
It's not helping your argument.
That doesn't make it impossible for the state to comply with the order. It just means that the state needs to be thinking along the way about who its witnesses may be. And that's why in our papers, we refer to it as a potential lay witness, because we believe that the court intended it to go beyond members of the prosecution team, which are law enforcement officers, retained experts, retained consultants. And we don't believe that that creates an enforcement problem. We don't think it creates a compliance problem. We noted in our papers, and I'll emphasize here again, that the court's order actually places responsibilities on defense counsel that the rules don't. The rules have special guidelines for the prosecution, and the court has expanded that to include the defense, and we don't have a problem with that. I also think that the standard that the state is suggesting for when a potential lay witness, as we've defined that in our papers, may make public statements that violate the court's order. The best standard is actually the one that we believe the court should look to, which is the standard set by the 10th Circuit, because as the state points out, it may be that there isn't any Utah law on this issue. So it seems to me that the closest source of authority on this constitutional question is going to be the 10th Circuit, and that's the case United States versus Tijerina, and I'll spell it. It's Tijerina, 412 Fed Second 661, 10th Circuit 1969, where the court says that the constitutional balance between the First Amendment rights of a non-attorney participant and the defendant's right to a fair trial are properly balanced where extrajudicial statements present a reasonable likelihood of prejudicing a fair trial. That is a more protective standard than that which appears in Rule 3.6. And we think it's the appropriate standard which should be applied here. That's part of, as we've told the court before, a motion that we will bring, because we actually think that while the court's order is wholly appropriate, it's not vague, it's not overbroad, it's not a prior restraint, it doesn't create a lack of clarity for the state. We would like it to be a little bit broader in other areas, especially concerning the standard to be applied and the definition of what is the prosecution team. But that's not germane to here. So we think that while we understand the state's concern, we think that their motion should be denied. I think at the last hearing, the court actually clarified verbally from the bench what it meant by a witness. And I think that's pretty close to what we described in our papers as a potential lay witness. So I feel like if I say anything more, I'm going to be reiterating again what's already in our papers. If I've muddled it, I'm sure the court will tell me and I'll clarify it. I hope I haven't.
Thank you, Mr. Novak.
Okay, thank you.
All right, and we'll turn to the last matter. Anything further, counsel?
Yes, thank you, Your Honor. I do want to point out that the court's order as it's written does impose limitations on speech. And the issue here is whose speech? Is it just the prosecution team members, or does it extend beyond that? And limitations on speech are a prior restraint. The court's order says that, if you look at page 2 of the order, it specifically talks about lawyers, that lawyers cannot make a statement that would violate Rule 3.6 and need to inform witnesses that they cannot make similar statements, and then requires the parties to inform lawyers, excuse me, I'll just read it. Lawyers participating in the investigation or litigation of this case shall inform all witnesses, and then the list that I read, about the prohibitions contained in this order. So the order is prohibiting speech. And because if it extends beyond the prosecution team, it needs to have the findings that are required for that kind of prohibition on speech. That's what we're asking the court to do.
Thank you, Mr. Ballard.
Thank you.
All right. Let's turn to the final matter before this court, the motion for limited intervention and request for notice of motions to close, seal, or reclassify. And I'll hear from the parties on that.
Thank you, Your Honor. David Ryman, representing the news media. Mr. Judd and I represent different groups of clients, so I'm going to invite him, if I miss anything, to weigh in after I'm done. But my intent, the issues are basically the same, so my intent is to address them for all of the interveners at once, and I'll be very brief. We have only ever sought, in this case, limited party status. That is what we do in every high-profile case that involves these type of closure issues. We are not seeking to be parties for all purposes. We are just seeking to be parties for the purpose of showing up and being heard, which we unquestionably have a right to do. We unquestionably have standing. That is settled law in Utah. And the last filing at least, that we got from Mr. Robinson's team that just came in, I don't know if it was a couple days ago, basically gets there at the end where it says, look, if you're going to grant them intervener status, it should just be limited. That's all we've ever sought. And so the question that was raised in the only case that they cite, this FL case from the Utah Supreme Court, that addressed whether we wanted to allow full party status under Rule 24 of the civil procedure rules in a criminal case, they said we don't need to do that. The woman in that case just needed limited party status. And so in a way, we're not really, the state really hasn't disagreed with this either, but we're not really disagreeing with Mr. Robinson's team. We have explained in our papers that we've cited the court to extensive authority saying that this is the procedure to use. It's the most efficient procedure to use. Otherwise, I don't know what exactly the suggestion is for Mr. Robinson's team that we're supposed to do from here on out, but it kind of sounds like just this sort of ad hoc show up anytime you happen to see something on the public docket that might affect the public's rights, and that's just not the orderly way that this typically happens. The other thing, as I've mentioned in our papers, that it does is it allows for the media to be able to take an appeal of a closure issue without having to rely on the court's extraordinary writ jurisdiction. And that was what they had to do in either Kearns Tribune or Bullock, where the media was not granted party status. And it is the situation that happened in FL, where they had to review her claim regarding records under extraordinary writ jurisdiction rather than invoking their appellate jurisdiction because she was improperly denied limited party status. So all of that authority supports the process that we are requesting in this case. We think it's the most orderly way to do it. And I'll end just by saying, you know, there's been some discussion, and especially from Mr. Robinson's attorneys, about what rule it is that you need to do this under, whether Rule 24 applies. They seem to suggest that it doesn't. I will just point the court to two different rules that give you the authority to do what we're requesting aside from Rule 24. Rule 24 is in the civil procedure rules, but Rule 81, and particularly subsection F of that rule, says that the rules of civil procedure govern in criminal proceedings where they don't conflict with a rule of criminal procedure. That's the case with Rule 24. That's why courts in criminal cases have relied on that rule. The other one is Rule 31, and that's in the criminal procedure rules. And that gives this court the discretion, if it's not inconsistent with the rules, to fashion remedies and to deal with civil procedure, not civil procedure, but rather just procedural matters. And so that is essentially what happened in the FL case, which is that, you know, whether you do it under Rule 24, whether you do it as a judicially created, remedy. It doesn't matter. It's the same, it gets to the same place, which is just that we are interveners for the very limited purposes that we've set forth in our order. We're not going to be here at every hearing arguing, we didn't take a position on the gag order motion that you just heard. We are only planning to appear and argue so that the court has the benefit of someone who's representing the interests against closure. Because as you know, and this is sort of why we're here today, a lot of time this just happens by stipulation, because these, the state and Mr. Robinson's lawyers, they may not want to fight over a particular issue. And so it really is a situation where no one really represents that interest. And the purpose of this whole process is to give the court the benefit of the briefing that we've submitted and the benefit of arguments to represent the public's right to attend these proceedings. So unless the court has any questions, that's all I have.
Thank you.
Thank you.
To the state, Mr. Beller.
Your Honor, as the state briefed in briefing on a prior motion, I think it's clear that parties have outside entities have the ability to intervene in a case as a limited purpose party when there's a statute, a rule, or case law that authorizes them to take specific action in a proceeding. And there's well-established case law that allows the media to intervene, to be able to appear and be heard on matters of public access to court proceedings and to court documents. And Rule 4-202.04 of the Rules of Judicial Administration also make it clear that the media can appear and do just exactly what they've done in the closed session that we held earlier. So it doesn't make them a capital P party to the case. It makes them a limited purpose party, and they certainly have the right to be able to do that. Thank you.
Thank you, Mr. Beller. Ms. Visser.
Thank you, Your Honor. So I just want to clarify the issue really, if we boil it down, is if these 23 media entities have met their burden to be a limited purpose party in this case.
Is that it?
Another part of that is what that means. And really that is what we are primarily concerned with. What does that mean? What does that enable them to do? What jurisdiction is this court exercising over them as a result of them being a limited purpose party? Because I do believe that is another aspect of asking to intervene in a case. I do think that Rule 24 does not apply here. I think that's what we learned from the Supreme Court. They don't want individuals using Rule 24 of the Rules of Civil Procedure because it's too expansive. It's about broad entry into a case for many purposes. In the instances where our courts have allowed intervention into civil cases, and I want to be very clear here, the case law is in the civil arena. There are very few instances where we're dealing with this in a criminal case on appeal. So
I wonder why.
we're a little bit in the dark.
Jurisdiction problem?
We're asking this court to kind of wade through and make a decision that potentially hasn't been made before. But I would ask the court to be very clear, no matter what it does, on what the media can and can't do in this case. And it sounds to me like the media has somewhat conceded that their role in this case is under Rule 4-202.04. And their role is to have a voice regarding closure, which has already happened today and will surely happen again. We have no objection to that. And to be clear, we're not objecting to the court's order about notice. We will provide notice. We will follow the court's order. We have no problem with it. But we do want this court to make the procedure very crystal clear. We want timeframes. We want orders saying this is when you need to respond, so that we don't end up with filings like we did this week, very shortly before the hearing, that we have to rush to respond to. We're all attorneys. We all know that these things happen from time to time, and we're not unreasonable folks. If they reach out to us, we will grant reasonable requests for extension, just so everyone is aware, but there was no communication. So I want it very, very clear what they can and can't do. It's less about semantics. This isn't about semantics, it's about substance. What are they allowed to do? If this court wants to call them a limited purpose party, that has to be, well, it's so you can exercise your rights under 4-202.04. And in doing so, this is what you need to do. That's what we're asking the court to do. And I also have some practical concerns that maybe need to be addressed with the court's clerk. For example, are we adding all 23 media entities to the court docket? Will they have access to all of the filings? I have had instances in the past where, unfortunately, parties have been added to a case and still receive documents that are intended to be private or non-public. I'm very concerned about that. So I think it would be appropriate, if they are going to be added to the docket, that it be reasonable, perhaps just the two entities that are requesting, the two conglomerate entities that are requesting, and that there be an order from the court saying if they receive something that they shouldn't have, they notify us in the court immediately and they delete it, they don't review it. At a minimum, I think that's necessary. But I also think it would be reasonable for this court to not to put them on the docket for that very same reason. So we don't think that they should have permanent status in this case. We don't dispute that they are going to be here. They're already here, as we well know. But we do think how that happens is important, and that this court should exercise its authority to make very clear what everyone's roles are here. And as I believe they put in their briefing, that they are neutral observers. Neutral observers. We don't want the chaos that is out in the media in this courtroom. So whatever this court can do to prevent that is what we're asking.
Well, just come to my
Does the court
channel.
have any questions for me?
No, thank you.
Thank you.
All right, counsel.
Thank you, Your Honor. Just very briefly, I'm not sure what neutral observer is supposed to mean. We have interests in the case. We are here to advocate for openness and against closure. And so I don't think that's what counsel meant to imply, but that's the whole reason we're here, is that no one else represents our interests. That is straight down the middle of what the intervention rule requires. Just a couple clarifications. Counsel said we haven't cited any criminal cases where this has been allowed. That's not true. We cited the court to 8 different cases, all criminal cases in the state of Utah, where this is the procedure that judges routinely follow, including judges in this building. Counsel said that our role is strictly limited to advocating for what is under Rule 4202.04. I don't think she meant this, but as the court probably knows, that just deals with court records. We're also entitled under governing constitutional case law to advocate against the closure of proceedings. And that rule does not technically apply to proceedings. It just applies to records. So just to be clear, but I think we have been clear, and this is all, I mean, there wasn't a whole lot of daylight between what counsel was just suggesting our role should be and what we've asked for, you know, which is just if they file a motion that seeks to prevent, that wants to classify something as non-public, like they did last night with the motion to disqualify. They were able to at least provide that to us. It's not very hard to send an email. That's all that we've asked for in terms of the notice. And then we have the right to be heard on those issues. And so I didn't really hear from counsel any reason why we should not be granted limited party status in this case, other than just some sort of, you know, confusion on their part as to what that would actually look like. I don't know how the clerk deals with parties on the docket. I assume you guys can sort that out. Typically, when we intervene on behalf of the news media in cases, they are listed because they are limited purpose parties. But the court can, you know, if it doesn't want to hear from us on a particular issue, it can certainly say that. I mean, we don't have any interest in weighing in on aspects of the case that don't have anything to do with the public's right to know. And so I didn't really hear an argument against what it is that we are asking to do. Just one last point on, well, two things. One is that counsel's chastising us for filing something late. I mean, this was a stipulated motion that got us here today. We weren't asked to weigh in on it. It was submitted to Your Honor with an order, you know, which they just assumed you would sign because it was stipulated. It was only because this court said, no, I'm not going to do that. I want to actually hear from the parties that we weighed in. So this was not your typical like deadline where we were invited to weigh in and just didn't. Last thing is, in terms of docket access, you know, Mr. Hunt and Mr. Jett and I are all officers of the court. If the court says you can have access to things that the parties are seeking to classify as non-public, but you can't share them with your clients until further notice from the court, that's fine. Some judges do handle it that way. Sometimes we just, you know, if they don't concern closure, sometimes we don't weigh in at all. But, you know, when they file things that they say we need to file this under seal and we're not allowed to see it, then the briefing for you is not super helpful, you know. And so typically the way this happens is we are allowed attorney's eyes only access to, you know, documents just like the state and the defendants would be. Their counsel can see things that are non-public, and we don't share them with our clients unless the court orders otherwise. And typically, if the court decides, no, this really doesn't need to be filed under seal, then we can provide it to our clients at that time. But this idea that our clients are somehow going to get access to things that are non-public, that's just not the way this typically works. If they're not public on the docket, if they're public on the docket, anyone can get them. And if they're not public on the docket, then our clients can't get them. And if there's a procedure where we can see them so that we can give the court the benefit of briefing substantively as to what it is, then we keep them attorney's eyes only until the court orders otherwise. So that's just typically the way this works. So thank you.
All right, anything further?
More, huh?
Your Honor, I'm not going to belabor what's already in the briefing. I do
But-
think it's concerning to just cite to a bunch of trial court cases without providing any pleadings or context for what occurred in those cases. I can't argue against what happened in other cases. This is our case. Our case is different. This court has already acknowledged it. There are many interests. We have concerns about leaks, information getting out that shouldn't be out. I think those are valid. And our concern is access. I'm not impugning the integrity of these gentlemen. I'm sure they would act as officers of the court. But the more this court controls the information that ultimately it determines to be private, the more able we are to identify if there are leaks, if there's information that's getting out that shouldn't be, and who did it. So we are objecting to providing the media our pleadings in advance, even just to their counsel. We don't think that's appropriate. I don't see any authority for that. We're asking the court not to consider that. And we're concerned about opening the door to multiple other entities, just filing in on this case, getting involved in the proceedings. We don't know exactly what media means either.
Oh.
So our position is and remains, they can file what this court has authorized to file in the manner this court authorizes to file it and be heard in the manner this court indicates. We understand they're entitled to closure hearings, and I did make a mistake. We agree that they have standing to object to closure as well. So they should be able to file those things, but we do not agree that that requires status in our case. So does the court have any questions?
No, thank you.
Thank you.
All right. I appreciate the argument from all parties throughout this day. I wish to commend the preparation and the quality of the arguments, as well as the civility that is sometimes overlooked, but I wish to recognize that and appreciate counsel's demeanor and their arguments today. I previously stated when we began that I would be issuing rulings on the first issue. And when I began, I initially said October 14th. It's actually the October 24th audio recording of the closed hearing, as well as the October 24th transcript of that hearing. And so I wanted to create, just make that small correction. But given the in-depth and necessary arguments made in the closed hearing, I wish to take the time to issue a ruling that will say what will be disclosed and what will be kept private, because this court has a duty to do so. And I would rather do it right and take more time than to be rash and miss the mark. I need to be narrow in my approach, and it is an important issue. And so I plan to do that. In regards to the motion for limited intervention and request for notice of motions to close, seal, reclassify, I also wish to craft my order in such a way that is concise and addresses all the issues, the important issues brought up by all parties. And so I will be issuing that ruling at the same time. And so I will be issuing the ruling in regards to the state's motion to clarify court's pretrial and trial publicity order, and I am prepared to do so. Before I do that, what I want to do is, and counsel is being caught off guard because they were anticipating a ruling today, but what the court is intending to do is, and proposing to the parties, is issuing an oral ruling on Webex that all parties can attend to. The reason why is I don't want to take a lot of time. These are important issues. I don't want to wait until January 16th. And I want to talk about potential dates. I don't imagine it will take longer than 20 minutes for this court to issue ruling. And I want to get the parties' input in regards to their thoughts of the court issuing an oral ruling on Webex. And so I'll open it up to the parties.
We don't have any objection to that, Your Honor.
Thank you.
We have no objection to that, Your Honor.
Yeah, same.
All right. Well, next comes the trickier part when you have a room full of attorneys trying to find a date that we're all available. To our staff, what dates do we have available for a 30-minute block before the end of the year?
Judge, we do have December 29th at 10 o'clock.
How does that appear? How does that date work for council?
That was 10 a.m. on the 29th.
Yes.
Your Honor, that works for Mr. Robinson. Thank you.
Same for us.
All right. And to defense, in regards to Mr. Robinson, what is your position on, if it is on Webex, he would be appearing by Webex, or is there different thoughts?
They're noticeably not asking him what he thinks about that.
Your Honor, if we could just have audio only for Mr. Robinson to appear, since we will not be present, I would rather not have him in the courtroom without counsel present.
All right. Thank you. I appreciate that. So we will set the court's ruling on those two issues for December 29th at 10 a.m. And note that it will be audio only for Mr. Robinson per defense's request. And to the last issue is, well, before I issue my ruling, I anticipate, and counsel, are we still on the same page in regards to our January 16th hearing? Are we planning for that?
Your Honor, we are. We believe that most likely what we would anticipate doing is on January 16th, arguing our motion to disqualify the county attorney's office, which was just filed. That should give them enough time to respond to that.
County attorney's
and also
office.
possibly we anticipate filing our own motion about the pretrial publicity order that has a little bit different take on it. That should be filed in plenty of time for us to argue that on the 16th as well. I think we have set aside the 30th, and that might be the one we want to save to argue our anticipated motion that's coming about keeping cameras out of the courtroom. And we will, I imagine the media will, depending on the court's ruling today, will want to weigh in on that one as well. And that would give them enough time as well. So that would be January 30th.
All right, and before I go to the other parties, the January 30th date, there was some complications. And so we have to find another date.
Okay.
And so I just wanted to let all parties know before we lock in our schedules, what dates do we have available for a 4-hour setting?
It's okay. My problem.
A lot of attention and
Council, I appreciate you
priority
giving me that
the
roadmap that
defense.
helps plan. So
on
and it allows the
talking
other
and
parties to
viewing.
take in consideration dates and filings as well.
Because they
So as
want to
staff
put
is
him to
doing that,
death.
They are looking for hearing
Zero
dates. One of
chance
the
he pleads
complications
guilty
is, as a judge,
without a
I
deal.
have 1,409 cases as of last Friday. And so trying to find a spot is tricky. And I'm grateful for my staff who work so hard to manage that calendar. So that is part of the reason for the delay. And we're trying to find a date because this is an important case, as is all of those cases. They matter to me.
Your Honor, while we're waiting, can I, if I might just make one point that might make things smoother as we go forward with the sealed filings? Just to Ms. Nestor's point, Mr. Novak earlier mentioned something about a redacted motion to disqualify. And I don't know if that is something that they're planning to file, but I was just going to say sometimes, what we heard earlier about that particular incident is probably not something that we care that much about in terms of what they would redact. And so instead of opposing the motion to classify, if Your Honor, I don't know if this is the plan already in this case or whether that's what they were planning to do, but if they file a redacted version that, just takes out the stuff they care about rather than closing the whole thing, then we don't have to say anything and probably avoids, fighting over unsealing that document. So I just wanted to say that. I'm happy to confer with counsel if you'd rather us do that.
We'll
if
chat
you don't
about
wanna
this
do
and
it
what the
by way of a
status
court order,
is.
but
No, I appreciate that input. I'll hear from both parties and then we'll get to the date.
Your Honor, I do anticipate going through and seeing what we can redact and working with the state on that as well and with media counsel. So.
All right.
And we agree that filing a redacted version is a good way to go. We can work together on that. As far as the January 16th hearing, the state will do everything it can to respond to these motions as timely as we can, as expeditiously as we can. I just want to note that that January 16th hearing was set with the expectation, the previous expectation was that defense counsel was going to get us these motions before Thanksgiving. And we just got the motion to disqualify last night. So we'll do everything we can to respond to those as expeditiously as we can and hopefully keep that date, but I'm not guaranteeing that we'll make that date.
All right. I appreciate the heads up. Going to staff, what dates do we have available for in lieu of the 30th? February 3rd, morning or afternoon setting?
Your plan? That works for Mr. Robinson, Your Honor.
All right, thank you. And morning or afternoon setting?
Either works for us, Your Honor.
All right.
As well as for the state, we're available on the 3rd.
The
anytime.
afternoon would be better because it may be that it reduces travel time.
All right. Well, it is always nice when all parties agree. So we have February 3rd at 1 p.m. It is anticipated to be in person. And Ms. Nestor, is Mr. Robinson planning on appearing?
Yes, Your Honor.
All right. Thank you. All right. That concludes that particular issue about future dates. And I appreciate counsel working with me on that. We have December 29th at 10 a.m. for the court ruling on these two issues, and that will be via Webex. And then February 3rd, January 16th, I believe that is at 1 o'clock. Is that correct? All right, that's in person as well with, I believe, defense has indicated Mr. Robinson will be present as well. And finally, February 3rd at 1 p.m. and also indicating that Mr. Robinson will be present. And in regards to the final issue, the ruling on the state's motion to clarify court's pretrial and trial publicity order. This is the order of the court. The court issued a protection order regarding pretrial and trial publicity in this case. The order prohibits attorneys who are associated with the prosecution and defense of this case from intentionally, knowingly, or recklessly permitting a witness, investigator, consultant, staff member, or other member of the prosecution or defense team to make extrajudicial statements, which, if made by the lawyer, would violate Rule 3.6. To that end, lawyers participating in an investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams about the prohibitions contained in this order. The state moves to amend or clarify the court's use of the word witness as used in the publicity order because it is vague, ambiguous, or overbroad. The state asserts that there are over 3,000 lay witnesses of the alleged homicide. The state does not know if it must inform each potential witness or each potential and possible witness of the prohibitions in order, or whether the order applies only to witnesses who are members of the attorney's teams, such as investigators or experts. Due to the potential confusion, this court grants the state's motion and offers the following clarification. The word witness, as used in this order, applies to all witnesses who are part of the prosecution and defense teams. This includes any witness, including lay witnesses, whom the prosecution or defense has a good faith belief will be called to testify at a hearing or trial. The court also clarifies that the publicity order as written regulates the behavior of attorneys who are associated with the defense team or the Utah County Attorney's Office. It requires the attorneys to abide by Rule 3.6 and, in order to deter non-attorneys from making prejudicial statements, requires the attorneys to inform witnesses about the prohibitions in the publicity order. Informing witnesses about the prohibitions in the publicity order is a necessary step. It is one moment as I regain my place as I read. Informing witnesses about the prohibitions in the publicity order is a necessary step toward not intentionally, knowingly, or recklessly permitting witnesses from making prejudicial statements. The publicity order does not regulate the behavior of any person who is not an attorney associated with this case. And this order will be signed today by myself and made public. Counsel, is there anything further that we need to address today?
Thanks, Your Honor. Yes, just the matter of having Mrs. Erika Kirk designated as the victim representative in this case. She has filed through her counsel a request to be designated as the victim representative. And we would like the court to formally acknowledge that request and formally designate her as the victim representative. And I guess along those lines, I wanted to make clear as well, I think this court stated earlier that there was an alleged victim in this case. And I know that there is case law talking about being careful about how we refer to victims and alleged victims. But in this case, that case law makes clear that those cautions don't apply with the same degree, where it's clear that we have a victim who was killed in this case. we don't have an alleged victim. We have an alleged perpetrator, but we do know that we have a victim in this case.
Thank you, Mr. Ballard. I'll hear from the parties.
Your Honor, on behalf of Mr. Robinson, we certainly think it's appropriate for Mrs. Kirk to be designated as the victim representative, if that is the desire of the state, just so there can be no doubt that she's afforded all of the rights assured to her under our state statutes, and we have no objection to that.
Thank you. Thank you to all parties. This court will recognize Ms. Erika Kirk as the designated victim representative in this case. Thank you. Council, I believe that concludes our matters for the day.
One
Or
more
maybe
matter,
not.
Judge. I can take the podium, Judge.
Yes, Mr. Gernander.
The purpose, I want to just give the court an update with respect to discovery. We've done that at
Thank
previous
you. I
hearings.
appreciate that.
The state has received approximately 13,900 files from law enforcement in this case. Approximately 300 of those we believe are duplicates. We have since provided to council, as of I believe this morning, 7,951 of those files. For the court's information, we had reached close to 100% had been disseminated as of last week, but we received quite a large batch within the last few days. So we were working on that. We still have a full-time paralegal that's dedicated to reviewing that, organizing it, Bates stamping it, and sending it out to council. Of course, there are necessary redactions that are being made along the way. Our next real hearing in this case, second matter, our next real hearing in this case is not scheduled till January 16th. We understand the court's caseload. We understand the difficulty of finding dates for a preliminary hearing. And we would like to make a request that the court calendar a preliminary hearing in this case.
All right. In regards to, and I appreciate the heads up and acknowledging the busy calendar of not only the court, but all of you. What, first of all, how many days does the state anticipate, which helps us in our calendaring efforts?
$1 billion
Given that it's a
question.
probable cause standard, and all the inferences go in favor of the state is asking for 3 days. We believe that we can present the evidence required to meet that standard, and that would also allow the defense to cross-examine witnesses and argue that standard.
Thank you, Mr. Gernander. Turning to defense, what are your thoughts?
Your Honor, we were not aware that he was going to make that request today. We do have one more member of our team that's not present that we would need to consult with. I don't know when he's talking about, but I don't see how we can set it until all the discovery has been received. And also we do need to deal with the disqualification motion just in case. So it doesn't seem like a good idea to set it before we have the disqualification hearing. We were only talking about a month from now. I think that should probably be resolved before we set any dates. But I am concerned about setting a date when we still don't have all the discovery materials. We have significant discovery materials that have not been received yet, that we know are out there and coming and important. And we have to, have time to review it all and absorb it all. And I am going to be involved in another trial that is not over until the end of March. So that's going to take away my ability to work and process through discovery and communicate with our team. So it seems to me that with the understanding of what Mr. Gernander is trying to accomplish, that maybe we come to the hearing on the 16th with an idea about, we can have some conversations with Mr. McBride and also with the paralegal that's dealing with all the discovery, and see realistically when we think we're actually going to have the vast majority of the discovery materials to us and how long it's going to take us to review it all. So maybe we could just come prepared in about a month to try to accomplish that.
Mr. Gernander.
Just 2 points, Judge. Sometimes I feel like we as practitioners sometimes lose sight of the purpose of a preliminary hearing. It is a probable cause determination. The primary purpose, according to case law, is to ferret out improvident prosecutions. So again, it's a probable cause standard. We are working as hard as we can, being very diligent with respect to collecting and disseminating discovery. Rule 16, subsection 2, speaks to the timing of mandatory disclosures. And it is our duty, it's a continuing duty. So as far as complete discovery being provided, in a case like this, complete discovery is going to be ongoing until probably trial. There are times when things become available during trial that are discovered to opposing counsel. But it says here, it says the prosecutor's disclosures must be made as soon as practicable following the filing of an information, except that a prosecutor must disclose all evidence that the prosecutor relied upon to file the information within 5 days after the day on which the prosecutor receives a request for discovery from the defendant. That's been accomplished. It then says, in every case, all material or information listed under paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary hearing. So we are in the process of that, collecting it as quickly as possible, making any necessary redactions, and moving it to the defense as quickly as possible. But complete discovery is not required before a preliminary hearing. We have to provide it as quickly as possible. We have that duty and we continue to do that. So we think we can schedule a preliminary hearing and work towards that. I'm aware of Ms. Nestor's schedule. I know she's going to be in trial, I think, in February and March. And I'm probably overestimating the availability of the court's calendar, but the hope would be sometime in April to schedule a preliminary hearing.
All right.
I'll submit it, Judge.
Thank you.
Your Honor, can I just clarify one thing? I mean, the county attorney has made a decision, very public decision, to announce their intent to seek death the day that there was an arrest, which means that that obligation to provide us with the probable cause for everything they relied upon to charge applies now to their intent to seek death. And we're nowhere near getting that material. So that was their decision to release that. Normally that decision is not made until 30 days after a preliminary hearing. They made it in advance, and now they've got an obligation to tell me their aggravation and what they've relied on to make this a death penalty case. And we have not received that. So I'm waiting, but I'm just laying that out there for now.
Thank you. I appreciate the arguments from all sides. I do not find there is any prejudice in setting a date for a preliminary hearing. It is not set in stone, and it certainly can be moved. I recognize that the parties have a lot of obligations, but I also recognize the importance of this case moving forward. And if nothing more, then this is a goal for the preliminary hearing. If it needs to be changed, the court understands that. That is what happens a lot in the criminal calendars and criminal dockets. What is a date that we may have available for a 3-day setting for a preliminary hearing?
The first week that we would have available is the week of May 18th. We do also have a week of some days in June.
We'll talk about this once they're done. It's got some significance
All right,
in
let's
terms
take a
of
look. So
rights
counsel,
that she has.
Well, what dates in June?
June starting on the 15th.
All right. Counsel, I'll turn to you. Again, this is a goal. This is not a date that if we can't meet, there's any prejudice that will be attached to a party. In regards to May 18th, how does that tentatively look for counsel?
May or June?
May 18th is the first date, I believe.
Oh.
So 18th, 19th, and 21st, just to give you the full range.
The state can make those days work, Your Honor.
Okay, perfect. Your Honor, we have availability the May 18th, with the understanding and the appreciation that if it's not feasible for us to get done when we need to get done prior to that, we would ask to push it back. But we don't have conflicts at this time.
All right, thank you. So May 18th, May 19th, and May 21st. And it will be in person. And do we anticipate, if that date moves forward, Mr. Robinson being in attendance?
Absolutely.
All right, thank you. I just want to put that on the record as well. All right, I don't want to be presumptive, but is there anything else? All right. Council, thank you again for your hard work today. And I wish you all, Mr. Robinson, a good afternoon. Court is in recess.
Thank you, Order. Thank you.
All right.
And they wisely cut the stream as soon as court went out of session this time. Guys, what is with this cameraman and the risky panning? He literally just told you. We got to order here. You got to be careful. You got to comply with it to the letter. And like the first thing he does is pan over to the defense table where they're reading their papers and we're looking at their papers. And he keeps doing this panning when you're in this you're in this orientation where you zoom out wide and the screen at the state's table is pointing directly at you. You just got super lucky they didn't have anything on that stream. Guys, the media is going to blow this. I'm going to call it right now. The media is going to blow this. Literally just got warned. Still couldn't figure out how to stay between the lines. They're going to blow it for all of us. So just be prepared for that, because I think that's going to happen. Well, let's go ahead and start with the recap of what happened today. Because we got here 4.5 hours ago and they spent about 3 hours in a closed session talking about redactions and their closure hearing. So that, I gotta say, I mean, he said, oh, it was necessary. He made his comments when he came back into court that it was necessary to have this detailed and intensive conversation about everything. But I gotta say, that seems like a lot of overkill to me. I don't know why this took 3 hours to talk about roughly, like, I don't know, six or seven redactions or so, maybe. It's just a little wild, but it did. So we entertained ourselves in the meantime, talked about some other stuff going on. When we finally got into session, the first thing we dealt with was a violation of the decorum order regarding the transmission of this proceeding. The defense presented on it. Under the rules of judicial administration, the court has the authority to terminate media coverage at any point in time with or without notice based on findings of violation. In this particular case, they argue that there were certain things that happened that were a violation that threatened Mr. Robinson's right to a fair trial. At one point, they argued his shackles were visible. They had, of course, an entire hearing about the potential prejudice of showing him shackled on camera. So that was a restriction to mitigate that. That apparently was not carried out. Also, possible audio from counsel table that was overheard, and then filming of the computers and materials at counsel's desk. I didn't see the shackles. I didn't hear the audio. I didn't see anything significant that was being shown at counsel table the first time, but I sure did after we came back. Definitely noticed they're like practically pointing counsel's paper like right at the camera, all zoomed in. So this is going to be an issue. So the defense wanted the judge to just yoink the cameras today, right now, off the bat. State didn't really push back. They just said, hey, if we think the order was clear and if there was a violation, there definitely needs to be some consequences for it. So then we heard from the media lawyer, of course. First time we've heard this. We don't know. We haven't looked at the video. We haven't looked at any of it. We don't know what's actually been captured. But he did acknowledge there was apparently an inadvertent capture of the shackles because of how they're zooming. Does it become inadvertent? Is it like still inadvertent when you're still doing your risky panning, already knowing that you've captured stuff you're not allowed to be filming and you keep doing it? Are they going to come back again the second time and argue, oh, when we were blasting whatever this note was that the defense attorney was reading all over the screen, that was just inadvertent. You freaking already knew. You already knew this was a risk and you still did it because they just can't freaking help themselves. They just can't help themselves. But he apologized. It was inadvertent, showing the shackles. And so he said they are working on basically editing the pool video so that when they disseminate it out, it doesn't contain that part. But they can't do anything. You can't undo the live stream. Live stream is done. Says, you know, the filming the computers in and of itself isn't the violation. It's just if it shows something on the screen, but he doesn't know what the shot is. I didn't see anything on any computer screen at any point in time, but the papers, you caught the defense attorney's papers, you caught the state's papers. They just can't. Reiterate that it must be followed to the letter. Your own lawyer is saying you must follow it to the letter, and he can't be bothered to do that. They're going to lose it for all of us. So the court did find a violation based on what's been proffered, but the exclusion of the cameras at this point, that would be disproportionate. That's going to punish us all just because this pool camera operator has shit for brains and can't behave himself. So I do appreciate that from the court. He emphasizes again the transmission. It wasn't even supposed to start until court's in session, meaning the judge is on the bench. Everybody is there. It's being called to order. They definitely didn't do that today. They started it early. We had all that kind of dead time of watching people show up in court and so forth. But they sure did end it on a dime as soon as he walked off the bench. So reemphasizes the order must be followed to the letter. He declared that the remedy for today is just to relocate the defense camera so that it's over on the other side. That was a good idea, Judge, but you see they can still zoom, and they're just not going to be cautious about what they catch on camera. They're not going to follow this order. Warning that future violations, the court does have the power to terminate broadcasting of the proceedings. Everyone's on notice. Still did it. Says the court takes very seriously transparency, but it has to be balanced with the right of all parties. And it also has to be balanced with the authority of the court, because I'm sorry, if you're going to make it clear you can't follow court orders, you're challenging him. And it's his courtroom, and he's got to be in charge and in control of it. So he's going to have to assert his authority if you keep flaunting your violations. Just unbelievable. So it's just disgusting. This is why this is why the media is such a failed institution itself. It's ridiculous. So we went first to the arguments about the pretrial publicity order, the gag order, and the state's just basically saying, we want to be sure we understand what this means because we're the ones that are on the hook if something happens. We want to be clear who it applies to. We want to be clear what exactly our obligations are, because it's not entirely obvious, and there hasn't been the kind of extensive hearing and findings and stuff that are normally required in the First Amendment context to justify limiting people's speech. He wants it to be limited to members of the prosecution team. That's what he thinks witnesses is, and because those are the people that he thinks they can comply with what the order tells them to do to take reasonable measures to prevent their witnesses from making statements publicly that could potentially be prejudicial to the case. He points out there are certain people involved here who have perhaps a heightened First Amendment interest in speaking, not to say anyone has greater rights than anybody else, which of course is true, including you, the press, versus us, the public. We're all on equal footing here. But he's clearly talking about Erika. That's really, I think, what their concern is. Erika is running an advocacy organization. Erika makes public appearances and gives talks and does interviews and provides her perspective about the case, the justice system, all of that stuff. She has a First Amendment right to do that. But now the state, are potentially on the hook if somebody decides, she's crossed the line, don't like what she said. I think that might be prejudicial. What could that be? That might be something as simple as, I think they have the right guy. Why is that? Because opinions on guilt by interested parties, people with inside information, are typically regarded as being prejudicial. People assume you're in a position to know, things that we don't know. And ultimately, the jury is the one whose opinion matters. Your opinion doesn't matter, but it can be very influential. So something as simple as that. Just wait. She says something as simple as that. The defense is going to be arguing violation, sanction the state. This is all being teed up. So they're concerned about Erika, because they know they're going to call her as a witness, of course. I said at the top, bare minimum, she is going to be a witness in a penalty phase of this trial. And she's highly likely to be a witness in the guilt phase as well. So the defense's response to this, they don't think there's a problem here at all. It only applies to the lawyers. They don't. In fact, they think it doesn't go far enough. We went through that at the top. Go ahead and go back in the live stream if you want to see the footnote number 2 from the defense's pleading, where they talk about how they want to gag a whole bunch of other people, including maybe Pam Bondi and the President of the United States. Waiting to see how that goes. So they've argued, they think it's clear. We understand what witnesses are. We don't have a problem with understanding that. And that's likely because, the defense is really not in a position of having a lot of narrative to push. Very, very likely to be as simple as that. If you had people with really helpful information that could help balance the public perspective on the case, on the evidence, on guilt or innocence, you think it's going to swing the pendulum way in favor of, at least doubt of the case, if not outright, we think he didn't do it. You would not be advocating that those people should be shut up. I can't help but notice, we got a little reply argument from the state where he's like, well, but no, it does actually impose restrictions on speech. The whole issue is just who is at issue. And this is the real problem that I see with this order, because it's really trying to have it both ways. And in fact, the judge kind of made it clear in his ruling. They are, in fact, trying to have it both ways, because what they're doing is they're not applying this order to the witnesses. They're not saying you witnesses are responsible for what you speak, and I'm gonna hold you accountable or penalize you for crossing a line. They're saying, I'm gonna hold the lawyers responsible for exercising some degree of control over you. And therefore, if you cross the line, we might potentially be punishing the lawyers for that. And it's just really unclear exactly what power this Utah state prosecutor is supposed to have over Erika Kirk. He's not her keeper. He doesn't have any legal power to muzzle her. So I definitely understand why the state is concerned about the way that this order is set up, is because they're very explicitly saying we're not applying this to the witnesses, but we really want to discourage them. We want to discourage them. That is like a super anti First Amendment position to be taking. He basically just said we want to chill their speech. We want to chill their speech because we want them to be worried about potential consequences. This is wild. Don't expect anybody is like going to appeal this or make a big stink out of it, but I don't know. I guess we'll see. Maybe the state will. Maybe Erika is going to raise some hell about, I have a right to speak and I'm going to. We'll just have to wait and find out. So we heard that argument. Then we moved on to the motion for intervention. This was like the very technical thing that I think the press lawyer just put it so well that like I'm not quite sure where the disagreement here is, because everybody understands we have a right to participate. The defense is just trying to make that as narrow as possible. They want it to be limited to participation under the rule of judicial administration. But as the lawyer pointed out, that's only dealing with sealing documents. That's just a process that they've adopted a specific set of rules about if they want to keep documents out of the public eye. It doesn't apply specifically to hearings. And as we can see, closing hearings appears to be a thing. It seems to be something we're going to be dealing with. Seems to be something we're going to be dealing with. They don't know who media is. How interesting is that? Am I media? Am I media? I'd like to know. I'm not sure if I'm media under the Utah standard. So it's really just about as the media attorney put it, the issue has to be the issue relates to what are their rights when it comes to being able to appeal, because if they're not a party to the case, you don't have a right to appeal. You're not a party. The ruling doesn't you're not aggrieved by it, even though it affects you. And this is just like one of these technical, formal, legal process things. So instead, you have to go through this other process. The extraordinary writ procedure is what he called it, and it's just a generally disfavored, form of relief. It's supposed to be extraordinary. Why do we need to use an extraordinary procedure if all you need to do is just recognize me as a party for this very limited purpose, so I can appeal the ruling if I think you got it wrong? State essentially agrees that, there's lots of law that says they get to participate not just on the document stuff, but also in the court hearings. It doesn't make them a full party, but there's plenty of basis to let them have the limited status. So the state doesn't seem to be opposing the media's position at all. It's the defense. And so they have kind of some humming and hawing. What does that mean? The issue is if the 23 media entities have met their burden. Well, you never argue that. So I don't know if that's really the issue or not. But she just kind of threw out a little bit of a shotgun series of mostly practical objections, like, well, does that mean all 23 of them are going to have to be added to the docket? And if they're added to the docket, is that going to create practical problems in terms of them being able to potentially access things in the file that are not sealed? The electronic record system, are they going to have access to things that they shouldn't have access to if they're going to be involved? Can we make it real crystal clear when their deadlines are? And stuff like that. So the defense clearly wants to sideline the press as much as possible. The press is not, the press wants this open. They want to know as much as possible. You, it seems, don't want that. It says a lot. But so they want to kind of marginalize the press as neutral observers, which the media then took some umbrage to. They are not a neutral observer. They are an advocate for public access. They are here specifically to adopt a position to suggest the court needs to follow it. They have shown all kinds of authority at the trial level. It's more than just the procedure, the rule procedure where they get notice of filings being sealed. There was a reference in here to a motion to disqualify. My ears perked up. No kidding. Motion to disqualify. Haven't heard this yet. So we'll take a look at that in a second when I get done with the recap. They're also asking for the possibility that because they have to have these closure hearings and then they have to argue about, what is even at stake here? Do we get to reveal it to the public? Do we not? He's suggesting you can maybe shortcut a lot of this process by just letting the media's lawyers get copies of these proposed sealed documents on a quote attorney eyes only basis, which is a thing that happens sometimes, like federal discovery protective orders, very common to include provisions that certain things are attorney eyes only. Certain types of cases of the type, I'm sure you can use your imaginations and figure that out, are real common to have things like that. So that was their proposal. One way to maybe make this a lot easier, just let us see it, limit it to the lawyers, and we'll only show our clients what you say we're allowed to do that. The defense doesn't like that because they are concerned about leaks. They're afraid there will be leaks. They didn't suggest there have been any leaks. They didn't identify any leaks. They didn't say, like, here's a piece of non-public information that's been out there in the press. If there is, that is definitely something to be concerned about. But just being concerned about something that hasn't happened doesn't strike me as hugely persuasive. But so they don't want to do that. They don't want to give their requests to the media lawyers ahead of time. They're also afraid about, if you grant this motion, what might it mean to open the door to multiple other entities, the slippery slope, the parade of horribles. Oh no, other media might appear in the case. Well, so what? So what? The public has rights. The media has rights. And you just got to deal with it. That's part of your job. Advocate for your position. Do what you're required to do. So what if other parties show up? I didn't really follow the reasoning from that beyond just a kind of general hostility to the public attention. So then we get to the judge's ruling. He commends the preparation quality and also the civility of the parties. You guys didn't sit there and call each other names in court. Good job. Good job, lawyers. Keep it up. Because this might shock you, but sometimes death penalty cases can get a little hostile, get a little contested. Probably a good likelihood that this one will at some point, but it didn't happen today. So let's go ahead and give everyone a pat and a biscuit for not giving into their worst selves on their presentations. So first off, he was originally going to rule on the redactions today, but after the in-depth and necessary arguments that he heard in the closed hearing, he's going to do a written ruling. He wants to make sure that he does these things carefully, does it right, take the time you need to do it instead of rushing and getting something wrong. Also, says he needs to be narrow in his approach, which is a comment that I appreciate and I very much hope he means, because yeah, you need to redact, restrict as little as possible. You need to be very clear on what the potential harm is, and you can redact everything that threatens that potential harm, but a single word that doesn't threaten it, you really shouldn't be redacting. So as far then as intervention, he also wants to do a written order. So he is not going to rule on those things today. Instead, he's going to write up a ruling, and then we are going to have a hearing December 29th at 10 a.m. where he's going to announce it. This is just going to be on Webex. It won't be an in-person hearing for Mr. Robinson. But as long as, I mean, Webex shouldn't be an issue because there's no camera in the courtroom for Webex. But as long as there isn't some sanction that comes down where we don't get to view that, we should presumably be able to watch that and see what he rules on those issues. So then he kind of turned to our scheduling, figure out what's going on. So we've had this hearing set for January the 16th, but it's not like entirely clear what that hearing is for. It got set back when they were still talking about when are we going to schedule the preliminary hearing. We had the motion for the shackling, the unshackling, and the civilian clothing, and they set this hearing out as essentially like status. We're gonna follow up and check in on what our status is. But we had these two dates, set aside so that things can be argued, but it really wasn't clear, what exactly is going to be argued. So the first thing we find out, January 30th isn't going to work. They're going to have to move it. January 30th has now become February the 3rd at 1:00 p.m. So no more January 30th. Instead, it's February 3rd. But then January the 16th, we are going to be hearing apparently a couple of things like a motion to disqualify, which has then been clarified as a motion to disqualify the county attorney's office. It's sealed. It's sealed. We don't get to see at this point what their reason is for why this county attorney's office shouldn't be allowed to prosecute the case. Generally, disqualification is going to be based on some kind of conflict. If you're trying to disqualify an entire office, then it's typically going to be because the elected DA has some kind of personal conflict or some kind of financial conflict. So it wouldn't surprise me if this is going to be something like, oh, the county attorney donated to Tea Party USA, or it could even be something as potentially remote as like the DA donated to the governor of Utah, and then the governor of Utah had this press conference and made statements that are prejudicial to Tyler Robinson. It could just be something like that, but it's going to be in the nature of that kind of issue. A disqualifying conflict that because it implicates the elected guy and everybody else in that office answers to him. So there's kind of an imputed, problem there. They have the incentive to keep him happy so they can keep their jobs, that the entire office would need to be disqualified. These types of motions do happen, not unheard of, sometimes win. And so if they win, what would happen? Potentially bring in a special prosecutor, potentially, I don't think they'd probably move venue. But you can bring in somebody, a prosecutor from a different jurisdiction. It's fairly common. We had a situation I've mentioned on the channel before over here in Washington. It's been several years now, but there was a judge over in Asotin County who got criminally charged with feloniously inappropriate behavior with his court staff. And so the local prosecuting attorney was not allowed to prosecute under those circumstances. They appear in his court. What if you lose the case? Now how are things going to go? So they've just brought in a prosecutor from one of the other jurisdictions, and that's not unheard of. The reality is just it would affect the time frame of things going forward, because now a new prosecutor would have to get up to speed. Little side comment about the judge having 1,409 cases on his docket. 1,409 cases on his docket. Dude, y'all need some caseload standards. Holy cow. That is an insane amount of cases to have going on and to have to manage. Maybe I'll take a peek someday if I can find it at just like your average criminal docket in Provo. Like, how long is it? How many cases are on it? I'm used to seeing case dockets that are, 50, 60 cases, not unheard of. Quite curious how they're managing to process all this through. That's a systemic issue, probably for another day. So then the media stepped up to kind of pop in about this motion to disqualify. Hey guys, maybe we could all put our heads together on a redacted copy. And everybody seemed to agree, yes, we'll file a redacted version so that we, the public, can see something about what the basis is for this argument. Seems pretty appropriate. So it looks like they're going to work on that. We'll see. So the January 16th motion is going to deal with that. It's going to deal with the motion to disqualify that's just been filed. And the defense, again, reiterates they're anticipating filing their own motion vis-a-vis the gag order because they want to shut more people up. They want to actually be able to sanction Erika Kirk personally if she goes out and gives interviews and not just, have to convince the judge that the prosecutor is somehow responsible for what she does when she's the CEO of a political advocacy organization. So then we got the ruling on the publicity order. He reiterates it prohibits the attorneys from intentionally, knowingly, or recklessly permitting their witnesses, team members, etc., from making prejudicial statements. They are required to inform all of their witnesses of these prohibitions. He grants the motion to clarify. This is he has a sort of magnanimous approach. Like a lot of judges would just be like, no, it's clear. I'm clarifying it, like in the sense that I'm giving you what I wanted. I'll tell you, I'll lay it down, what we're doing here. But I don't like your motion, so I'm not going to grant it, or just I'm hostile to you, or I'm hostile to this process, or I don't like you, taking up my time, asking me to have to do this. Figure it out for yourself, kind of thing. But he doesn't do that. That is not his demeanor at all. He's very magnanimous. He's going to grant the motion to clarify, and he goes ahead and clarifies that the witness. Now, is this really a clarification? Because what he says is that when he uses the word witness, he means it applies to all witnesses who are part of the prosecution or defense teams. But that means potential lay witnesses that the attorney has a good faith belief will be called as a witness in a hearing or trial. So not really the member of their teams as you normally think about it, as in like you come to our meetings, we have confidential communications about the case. We maybe have a contract. We maybe have statutory duties, stuff like that. Doesn't mean that. It's like, yes, we'll say it's the member witnesses that are part of your teams, but I'm going to still define very broadly who is on your team. And I'm going to count lay witnesses that you plan to call at any point in the process as members of your team. And so the purpose, it only applies to lawyers, very clear. The gag only applies to lawyers, but we acknowledged explicitly on the record, the purpose is to deter the witnesses from doing that, from making, statements that they think could be damaging. The lawyers are required to inform the witnesses of the provisions of the order. And that's a necessary step towards preventing or protecting Mr. Robinson's right to a fair trial, preventing any type of prejudicial disclosure. But he didn't say that's all they have to do. Just that's like the minimum they have to do. So it's still not really that clear. How responsible is the prosecution for what Erika Kirk might have to say? Clarifies it does not regulate the behavior of any person who is not an attorney in the case. So on paper, she is free to speak, but the state might be sanctioned for it. And if the state is sanctioned for it, what might that look like? Well, one of the things that the defense team is always looking for in a case like this is, can we take the death penalty off the table as a sanction? Might be considering stuff like that. So does this kind of clarify the playing field and how these chess pieces are being moved and how the strategy is going? Because My view after this hearing today and what's happened, Erika Kirk speaks at her own risk. There is a threat that is hanging over her, making comments, giving interviews. Everybody at Tea Party USA who's a potential witness, even if they have been attacked, maligned, might want to defend themselves. They speak at their own risk because the court might sanction the state for it. And sanctions to the state might mean things like, we're going to take the death penalty off the table. And so now, do you think if any of these people say anything at all, the defense maybe has a little bit of an incentive to bring it to the court and argue that's prejudicial? What they did is prejudicial. And the state didn't prevent it. So judge, take the death penalty off the table. They have every incentive to do that, to litigate to the gills any public statement that any of these folks make. Quite a chess game. What do you think those people are going to do? Do you think that even though this order doesn't apply explicitly to them, they're going to be chilled in their speech? They're maybe going to think, yeah, I am discouraged. I am disincentivized. I will go ahead and not say anything because I don't want to cross that line and potentially be the reason for some kind of sanction that affects the case. We got then the formal request and confirmation that Erika Kirk is going to be designated as the victim representative in the case. We will turn to that real quickly too and talk about what that means. Had a little bit of a kind of back and forth discussion of language because lots of times there's issues about, alleged and, the language that you use to describe people and things. And is somebody a victim or an alleged victim? It's really appropriate to refer to somebody as an alleged victim when there is a question about whether a crime has even occurred. But that is not this case. Charlie Kirk is clearly a victim. His family is clearly a victim of exactly what crime by exactly who is at issue. But they're clearly victims. Like this is not a situation where using that language is particularly problematic. The defense didn't really take issue with that at all. Agreed it's appropriate for her to be the designated representative. We got the discovery update then from the state. They have received a total of 13,900 files from law enforcement. About 300 of those are duplicates. They have provided a little over half of that to the defense, 7,951. They were close to 100% turning everything over last week, but then they got a big batch. And the reason why this takes time is because they have to go through everything that they receive. They have to redact anything that they're required to not disclose. They have to bait stamp it. So the bait stamp is like it's this old school numbering method to just, consecutively number pages of things. Very common to do with high volume discovery like this so that you have some kind of common reference point for what all of this stuff is. You're looking at one photograph. How on earth are we going to find it in this massive information? Well, if it's, it's at bait stamp 14,502, you can flip right through to that and everybody's on the same page. So that is going to take time, but he's letting the court know that is ongoing. They are continuing to comply with their obligations. And they want to go ahead and get the preliminary hearing on the calendar. They think it's going to take 3 days. The defense is like, we weren't expecting this. Say they don't know how we can set it until all of the discovery has been received. Maybe wait. But the state says, look, this is just a probable cause hearing. This is not a trial. It's the mandatory disclosures have been made, but there's always going to be ongoing stuff that trickles in all the way up to the point of trial, which is unfortunately true. because things happen and things change and people say things, and you come up with last minute stuff. It just happens routinely. Sometimes it's not in good faith, but a lot of times it is. Just part of the process. So the defense then is taking issue with that because they say, look, you weren't required by law to file the notice of intent to pursue the death penalty until after the preliminary hearing, but you did it before. And so because you did that before, whether he is appropriately, charged with an aggravated murder offense, and whether death is appropriately on the table, means that those things are now at issue. So the discovery related to that decision needs to be turned over, and that hasn't been done. I'm not sure what exactly they mean by that, discovery related to that. It seems to me it would relate to just the same evidence that supports the elements of the charge that they've brought, which in Utah is the aggravated murder charge. I'm not aware if they have to independently support like their discretionary decision to pursue death in a case that is, otherwise legally qualifies for it. But nobody seemed to kind of dispute any of that. The judge is like, look, we can set a date because we can always move the date, which is so prudent. This judge, I don't love everything he does. I don't love these closed hearings at all. But it's just, I have a hard time not finding him so pragmatic. So pragmatic. Yes, you can set a date and then you can move it if it doesn't work. But everybody is busy. If you need multiple days, look, we already have to wait until May 18th, 19th, and 21st. Are the days set aside for the preliminary hearing, with the understanding that if everybody isn't ready, then we'll move it. 5 months down the road, guys. That's our pace in the court. That's our pace. The news cycle is just not not in the same universe when it comes to that. But the preliminary hearing, yes, it's going to be 3 days worth of evidence. It's going to be very significant. They've confirmed everybody plans to go forward with it. So it's the defense is not waiving it. So we're gonna get some evidence if folks can be patient for 5 months until we have this hearing and find out. So I got a couple of things real quick that I am going to share with you. The first thing I'm going to share is I went ahead and got myself into the court docket. This is their electronic filing system where I get all of the documents that I put up on Substack just to see what's going on. And so this is what they've been talking about, these motions to disqualify. So they've already filed it. They already requested that it be treated as private. That's already been like presumptively granted for it to be filed privately. So we aren't seeing any of that. And all we know at this point is that it's involving the county attorney's office, and they're going to maybe be able to agree on a redacted version to give to the public. And if not, we're going to have a whole other closure hearing probably at this January 16th date. We're going to, are we going to get to be there for that? Not clear. Is it going to be the same thing as this? Maybe, probably, not really sure. So those are new things on the docket. This I'm going to pull up for the questions about, where is it? Did I just lose it? I did. Let me bring it up here. Questions about the victim's rights. That is right here. You guys see that? Yes. So this just gives a good overview. You can go straight to the statutory bases for these requirements, but it also gives a really good overview of specifically what it means for you to be designated as the victim representative. And that's because Utah, like I don't know if it's every state in the union so far, but it's certainly a lot of them have recognized rights for crime victims, certain rights to be informed, to have notice of what's going on, basically just not to be cut out of the process and, have the prosecution making all the decisions that they make over the course of the case without any kind of input from the victim about things like, if I'm going to offer a plea deal, does it seem okay with you? It's not like it gives them a veto power or anything like that, but it's really just supposed to give them a voice in the process. So here's what they get. They get a right to be informed as to the level of protection from intimidation and harm available to them and from what sources as they participate in criminal justice proceedings. They get some protection from intimidation and harassment by certain sources. So they're going to be conferring with law enforcement about that. Do you think Erika is getting any intimidation and harm? Do you think Tyler's family is getting any intimidation or harm? They're a witness. They're not a victim, but she's the victim. They have a right to be informed and assisted as to their role in a criminal justice process. So many places will have a designated victim representative. We heard about that in the Karen Reed case. I've already spaced on his name, but he's the one that Carrie Roberts called all the time, and Jen McCabe called all the time. Very, very common to have a person like that to just sort of be the point of contact and a listening ear and help connect them with who you should talk to about certain types of concerns and things like that. Right to a clear explanations regarding relevant legal proceedings. So they get to know what's going on. They don't have to read the court docket and try to interpret it for themselves. A secure waiting area that does not require them to be in close proximity to defendants or the family and friends of defendants. It can be very intimidating in certain kinds of cases for people who are supposed to be coming into court. If you're getting a stare down from either somebody at the table, folks in the audience, stuff like that. This comes up a lot in gang types of cases in particular. So they get a secure area. They may seek restitution or reparations, including medical costs under all of these restitution acts. They have a right to have any personal property returned as provided in these other sections. So when your property is taken as evidence of a crime, processes for you to be able to get that back. Victims and witnesses have the right to reasonable employer intercession services, including pursuing employer cooperation in minimizing employees' loss of pay and other benefits resulting from their participation in the criminal justice process. This is normally for you're getting called into court and your boss doesn't like it and your boss is pissed. So the prosecuting attorney or the victim representative or whoever can call up your boss and be like, they're under subpoena. It might be cool if you could be cool about them needing to come into court. Victims and witnesses, particularly children, should have a speedy disposition of the entire criminal justice process. That essentially means that speedy trial rules kind of are what they are, which is to say that they are nominal. There is a constitutional speedy trial limit that basically says that after a year of delay, you might be able to show a speedy trial violation, but you have to show it's in bad faith. It's the other party's fault. You haven't contributed to it. There's no reasonable justification for it, that type of thing. But victims also often have an interest in getting this case done. They're in limbo. They often have, subpoenas hanging over them, their property in the possession of the court, stuff like that. So this basically just means courts, when you're considering hearing settings and trial settings and stuff like that, you're not just considering whether the defendant has a speedy trial right and wants to invoke that, because sometimes defendants want to kick things down the road as long as possible. You also need to consider that the victim might have an interest in getting things done quickly. The right to timely notice of judicial proceedings. They are to intend and timely notice of cancellation of these proceedings. Somebody at the prosecutor's office needs to get up on the phone and tell them what's going on. Sexual offenses isn't going to apply here. And so all this sexual offense stuff doesn't apply. So these rights are based upon the victim providing basically your contact information to themselves, to the person to whom the information should be provided. That's what this designation is about. This is designating Erika as the person who should be receiving this information. So that is who is going to be contacted. That's, the general outline. There's a lot of specifics here that you are more than welcome to go through. But I just kind of wanted to give you a broad outline of what that was about, what that means. Again, it doesn't mean like she's a party. It doesn't mean she gets to make calls about what happens. But it does mean they're supposed to listen to her. They're supposed to consider her. They're supposed to the extent possible, get her input on things. So that's what that designation is about. Guys, it's been a long day. Holy cow, and I barely only had one cup of tea. We're over 5 hours in here. What have y'all had to say while we've been watching court? Mavka and Sky, as defendant, do you ask him if he did it by now or ever? This is a question that you will find many different philosophies on in the defense world. Some people, yes, will ask. Some people say, I don't want to know, because once I know, I can't present a defense that is potentially inconsistent with what you've told me. And so the more you've told me, the more restricted my options are to ethically be able to defend you against the case. So some attorneys will be like, I don't even want to know. I don't really care. They just, we'll be reviewing the evidence and we'll talk about the evidence. And when the time is right, we will talk about whether you want to testify or not, and what you would say, and all of that type of thing. But some attorneys will do that early on because, it's maybe better to know early in the game what kinds of roads you might want to be going down with your defense rather than waiting until late on. I mean, the reality is like, let's say Tyler Robinson has told his lawyers, yeah, I did it. Yeah, I did it. Well, you've got a fairly limited defense now because you can't put him on the stand to say, no, I didn't do it. You can still challenge all the state's evidence. It's not authentic. It doesn't clearly establish guilt beyond a reasonable doubt. It was obtained in violation of his rights, all of that type of thing. But you limit certain avenues to put on like a factual innocence defense if he tells you he's not factually innocent. And that can cut both ways. This is a death penalty case. You got a lot to work on and a lot to worry about. And so it might be better to know that now so that you can focus your efforts on the stuff that is a little more promising in terms of potentially being able to get a better outcome, a more favorable outcome for him. Maybe we focus much more on the mitigation. Maybe we even anticipate doing a taking responsibility type of case. This is not unheard of either in death penalty cases, where if the state's not willing to deal, state's not going to take the death penalty off the table, but you don't really have a case for innocence. It's not uncommon at all to go into that trial, be like, look, he did it. He just doesn't deserve the death penalty. And then you get to use the fact that he's taking accountability, he's being remorseful or whatever, as grounds for why he shouldn't get death. So there's a lot of these considerations, going on. Attorneys have very different approaches and philosophies about it. I don't know what his team is doing, but there's a lot of different ways to handle that. D. Rover, our interests should be the court's interests. They should, right? They take an oath to protect and defend the Constitution. Idaho or Utah as well as the United States Constitution. So we should all be on the same page. But the reality is that we, the public, are often kind of a pain in the ass to the court. And it's, at least institutionally, structurally, kind of contrary to the interests of the court to be overseen by the public. You know, if we watch too closely, then we might judge, and if we judge, we might judge unfavorably, and if we judge unfavorably, we might not want him to keep his position. So there's a lot of conflicting things going on. I don't necessarily love that the media is supposed to be there representing me, the public, because the media has an interest in monopolizing the flow of information. And that's contrary to my interest as a member of the public to have a free flow of everything and not have to, you know, pay money for it or whatever. But yeah, it's just kind of how things are set up. Big Dog 5758 is a member. Welcome, Big Dog. Good to see you. Chugi Live. I am just confused. Is Erika considered a witness that can't comment publicly? What about TPUSA and wanting to respond to Candace? They are not explicitly covered by the gag order. They are not personally going to be punished if they speak. But if they speak and the court thinks they've crossed the line and they've not been adequately, you know, dissuaded from doing it by the state, then the court might hold the state accountable. That's just kind of where things stand right now. They're not going to be personally punished for doing anything at all, but they kind of have this, you know, threat of jeopardizing the case dangling over them. Is that the way it should be? I don't know. That's a pretty philosophical issue to me. I think the whole background with just the sort of attacks that are going on some of these people is not really it's not really normal. You just aren't normally in this type of situation where people who are witnesses just have such an incentive to respond and defend themselves. So I really don't know how this is going to go. She's considered a witness. She will be considered part of the prosecution team, because there is no doubt the prosecution is going to call her as a witness at a bare minimum at a penalty phase, because she's the one who is most affected by Charlie Kirk having been murdered. And so she's going to be there to testify about the effect of that, if nothing else. Michigan Farm Boy, if cam operator shows a doc that compromised the defense and causes a mistrial, could that be contempt? Maybe even if a less serious violation? It can be contempt. If it violates the order at all, even if it shows a paper that it doesn't matter at all. They're playing tic-tac-toe over there at the defense table and they catch it on the computer. It's against the order. You're not supposed to be filming their papers. Probably wouldn't be great to see that that's what they're doing over there at the table anyway. But I'm just saying, like, it doesn't even have to be substantive about the case or material to the issues that are going on in court. You are not supposed to show the papers. And so, it can be contempt, because you knew this is the order that you're under. You are kind of charged with knowledge of that order by operating the camera in the courtroom subject to that order. So if you don't follow the order to the letter, you can be in contempt. And there can be penalties for that. Those could be personal penalties. Maybe we're going to fine the camera operator. I would like it to not be, we're going to yoink the cameras out of the courtroom, but I'm kind of going to understand if it is, just like I did in Koberger. You know, if you're not going to follow the rules and you're going to thumb your nose at the court, he's going to show you whose courtroom it is. You don't get to make the rules. Just hope it doesn't come to that, but I gotta say, I'm not particularly optimistic at this point. Nope. W. Imopan. Nice name there. What can the judge do to the camera operator punishment-wise for this ultra zoom on defendant nonsense? He could ban this particular camera operator from running the pool camera. He could, ban whoever he works for, whatever agency he works for from being the operator of the pool camera. He could fine this person. He could fine the media agency. The judge has very broad discretion to craft a sanction or a remedy that he thinks is going to be appropriate to violate or to remedy what happened, prevent future violations, deter future misconduct. So, in any of those things, just kind of the first things that come to the top of my mind, he could do something, these are like personal for the cameraman, or, that nuclear option that's hanging out over our heads now, that maybe just pull the cameras out of the courtroom altogether, because they literally for 20 minutes can't be responsible with how they operate the camera. Jersey Jen, Andrea on 4 hours so far. Give her some love. TikTok, guys, TikTok. We are 5.5 hours in. It's been a minute. David Livergood, 5024 is a YouTube member. Welcome to the channel, David. Appreciate having you here. Yeah, guys, it's been a minute. I'm getting a little dry. It was a beautiful day outside when we started. It's now dark. It's already time for me to go gather up the chickens, get the door closed. I'm honestly surprised I haven't been attacked by cats worse than I was. We just had a little Gus check in, but that was it. I'm sure they are. This is like getting to be their dinner time, so I'm probably gonna get pestered pretty soon here. Porkins 1802, yo, Andrea, love your content. So are they fitting this kid up? The facts reported on the day seem to say patsy thoughts. My view of the probable cause affidavit is that if they have what they say they have a very strong case against this kid. They got his DNA on this gun. They've got, him on the camera. They've got him making confessions to his family. They've got him making confessions to his roommate lover. That's just what they have in the PC affidavit. They're going to be able to, cross-validate a ton of that with things like his location data. They're going to be able to track his cell phone and look, for example, this individual that we're watching on camera, on the roof with the gun, et cetera, at these particular points in time, we can potentially track that through his location data on his phone. If he's got location services on, did you need a map? Did you need to use Google Maps to know where you were going? Then you have location services on. And this kid doesn't seem particularly sophisticated about what evidence is available. He thought if he went and got his gun back that there would be no evidence. No, honey, there is going to be a digital footprint. If it was you and you had your phone and the person on the video camera had a phone, and we're going to be able to look at your Tyler Robinson's phone activity and see, oh, hey, is there something here that corresponds with that phone activity at 11:53? We're going to be able to track the location. If he's got GPS data from location services, that is often extremely precise. So we're going to be able to follow the path and see if it lines up. Like, if they have what they say they have, then they should have more. And if they do have more, no, this isn't a frame up. So it kind of remains to be seen. I continue to think there are probably some open questions about was this really a solo thing? Did he really do this alone? But we're not seeing the kind of moves from the defense that you'd expect to see if this has all been like a big fabrication or a big mistake. Because you'd expect a lot more noise. You'd expect a lot more filings. You'd expect a lot more, like, he's been in jail for 3 months. And where's your due process issue? Okay, if you've talked to the family and the family's like, no, we never turned him in to jail. He never said those things to us that are being reported in the probable cause affidavit. You're going to be filing something because that would be misconduct for the state to have put it in there. And state misconduct means we might need a remedy, and the remedy might be, we need to like get this guy out of jail, release this guy, give him some kind of bail, something like that. Because it kind of looks like maybe this is a frame job. The defense is the most incentivized of anybody to come up with that type of thing. And so the fact that they haven't, just telling you, it should say something. But we'll know more at the preliminary hearing. We'll know a lot more at the preliminary hearing when we get to see the evidence and what it's based on, and see if there's any challenge that the defense has to it that they have heretofore not voiced. So that's really my take on it. I'm not getting a frame job read at all, but remains to be seen. So stay tuned, I guess. All right, guys. With that, I'm going to go ahead and check out, get myself some more tea, get my chickens all safe in their coop, get the cats fed, see what happened today in the rest of the world outside of the Tyler Robinson court hearing. I want to thank you guys all for joining me here. I do appreciate it. I appreciate your interest in this case. As I said at the top, this was really not one that is super compelling from a did he or didn't he do it kind of standpoint. It's never really on the table that we were going to get more information about the basis for the charges or anything like that. But it's the transparency side of it is what is so important. Because, we see there are a lot of questions about this case and a lot of uncertainty maybe about how the court process works. And you're not going to be able to dispel the suspicion about this case and whether the court is going to be an adequate mechanism to vet the innocence or guilt of this accused if you do it behind closed doors. So the more we get to see, the better. Really, really important premise of our legal system in general. And that's really what today was about. So thank you all for caring enough about that to show up and watch this with me. So with that, guys, I am out of here. Enjoy your evenings. Take care of yourselves. I'm going to be revisiting my initial plan to stream tomorrow morning. So I might need a little voice time. But if you are signed up, whatever, you know the things, you know how to use YouTube. I don't have to tell you how to do that. But if I do get that set up, want to be in a position to get notified, you know how to do that. So just stay tuned on that. I will be doing a follow-up on Luigi Mangione at some point. And continuing with Christy Martin. Guys, any of you interested in that? The Jim Martin trial. This was the movie, the Christie movie that should have been better. Unfortunately, just wasn't a very good movie. But it is quite a story. Christy, herself, awesome, badass champion boxer, world champion. Great fights. Always put on a fantastic show. So we've been rewatching that. There's going to be more of that coming up as well. And just as things happen, I'll continue to monitor the docket and other cases and stuff like that. You guys saw Mickey Steins. We had some stuff finally happened in the Mickey Steins case. He had moved to dismiss the case for grand jury irregularity, and the court basically said no. But they did say he gets to have a bail hearing. So there's going to be a bail hearing in that case. Don't know when yet, but I'll be interested in watching that when we get to that point. Because I suspect it's going to relate to this sort of weird looking mental health, extreme emotional disturbance defense that has been hinted at which is a little weird with like the California encephalitis he was talking about in his deposition just a couple days before. Guys, it's weird. I wrote about it on Substack if you're over there. So anyway, keeping an eye on that as well. Guys, I'm out of here for real. Thank you again. Appreciate all of your support. And yeah, stay tuned. I will see you next time. Enjoy your evenings, folks.